Good morning, Judge President Mlambo.
Good morning, Deputy President, and good morning, Speaker, Minister, Commissioners.
Will you please switch your microphone on? It's on, thank you. Are you well this morning, Judge President?
I've lost 5 Ks since Monday. I think that tells you how I feel this morning, Deputy President.
I'll allow you just a few seconds for you to settle down, take a deep breath, then we'll proceed with the business of the day. If you could then give me a signal when you are ready.
No, we may proceed, Deputy President.
Thank you. Just for the record, shall we confirm that you know all the members of the commission sitting around this table?
I do indeed.
And speaking for myself, I've known you for several years.
That is true. Our meeting was not a very pleasant one because I was part of a bench that reversed your judgment.
But only partially.
Yes, well, that's an occupational hazard of every judge.
Thank you. And again, for the record, I want to say that you are one of the 4 candidates who were nominated by the President of the Republic of South Africa for the vacant position of the Chief Justice of South Africa in terms of the dictates of the Constitution. And we welcome you too to this session of the JSC.
Thank you, Deputy President.
You were born in 1959 and you are 62 years old and will be 63 on your next birthday in September.
That is correct, Deputy President.
And you are married with 4 children.
That is correct, Deputy President.
Were you to be appointed as the next Chief Justice of the country, you would serve at the most 7 years in terms of Section 176(1) of the Constitution.
That is correct, Deputy President, until I reach the age of 70.
Which is almost just 7 years to go. You hold the degrees of BProc and LLB and the University of Forte conferred an honorary doctorate on you.
That is correct, Deputy President.
And that was in 2019. In 1997, you were appointed as a judge of the Labor Court at the youthful age, in my view, of 38 years.
That is correct. I started with the acting Chief Justice at that time in the Labor Court.
And you are currently the Judge President of the Gauteng Division of the High Court of South Africa.
Indeed, Deputy President.
And before your elevation to the bench, you were a practicing attorney, and at some point you were a councillor, not a municipal one, Law Society councillor of what was then known the Transvaal Law Society?
No, I was not a councillor. I was just a member of the Law Society.
Member of the Law Society, thank you. And at one time or another, you held membership of various organizations and bodies.
That is correct, Deputy President. Sorry.
Would you share with the Commission the identity of those organizations or some of them?
Well, early in my career, before I started the practice of law, I joined the fellowship program of the Legal Resources Center for a year. I think that was in my early days, but I was a board member of the, I remain a board member of the ILF, International Legal Foundation. It's an international body. I chair CAUSA, the Community Advice Officers Association of South Africa, which is a grassroots legal services platform serving the vulnerable sectors of society. I was a director or board member and then chairperson of Legal Aid South Africa. As chair, I stayed for about 17 years. I was a board member of Africa Legal Aid, or AFLA, which is an NGO based in The Hague, but focusing on continuing legal debates and discussions with African diaspora on international forums. I'm a member of the, well, until last year, I was a member of the Legal Resource Center Trust. I think, yeah, I can mention those, Deputy President.
Thank you. In paragraph 18.7 of the questionnaire, you state that you subscribe to the principle that leaders of the judiciary should be accessible to the judges that they lead. Why did you find it necessary to underscore that point?
Well, it is my experience as a leader in the judiciary that visible leadership instills confidence in those that are led. And it's been my practice. When I took over in Gauteng in particular, I found that Judge President Mwepe only had chambers in Pretoria. And he did come to Joburg, but on rare occasions. And I discovered that if I had chambers in Johannesburg as well, and I told this to the judges that I will be visible and in their face, and my door will always be open for them should they need any assistance from me. I found that visible and present leadership goes a long way in instilling confidence in members of the bench. That's the reason I can mention.
Do you at all subscribe to the principle that a head of a court is just a leader amongst equal, in effect, equals?
Well, he's the first amongst equals.
Yeah, yes.
He's a leader, yes. And I think just to underscore the other point that we're discussing earlier, there's some convention that I found when I became head of court that JPs don't go into judges' chambers. Judges go to the JP. I don't subscribe to that. I would surprise judges by simply walking into their chambers and just chatting with them. And most of them, especially in Johannesburg, because they were not used to a visible JP, they would be shocked at seeing me in their chambers, and they would ask, "What are you doing here?" I said, "Well, I've come to check on you." So I just thought, let me mention that.
And I guess some would even tell you that you should have picked up the phone and asked them to come to your chambers and they would immediately run to your chambers.
Correct. I mean, it's worse, Deputy President. When I took over those times, 2010, 2012, judges believed in sending written communication in physical form. Because of the engagements I have, sometimes I would be away from my station for some time, and you'd find a couple of letters waiting for me, and I would tell them that, guys, I have an email. Just send whatever you want to me by email. And that was the beginning of a journey in conscientizing the judiciary spaces that I've been involved in, that there's a lot to be gained in taking advantage of technology.
Yes, thank you. In paragraph 18.8, you make the point that it is essential that courts and judges should be adequately resourced to enable them to do their work efficiently.
That is correct. Should I comment on why I said that, Deputy President?
Well, it's self-evident, but what I want to pose to you is, are they, as you are sitting there, would you confidently say that they are adequately resourced?
Definitely not. And I can expand if I'm allowed to.
Perhaps for the benefit of the members of the Commission, I will allow you an opportunity to do so, albeit briefly. Thank you.
I'll mention two aspects that I've touched in my vision statement. One is the adequate capacitation of judicial establishments needs to be looked at. The workloads in the courts are continuously increasing. That means judges are continuously carrying bigger and bigger caseloads. I'm taking more from my experience in Gauteng, as well as the labor court. I don't want to leave it behind, because that's actually a very busy court as well. So that's the adequate resourcing from a judicial establishment point of view. The minister will know that he has established a subcommittee chaired by Deputy Chief Justice Mbuyiseli to engage heads of courts as to what the ideal capacitation needs are from an establishment point of view. So that's one aspect I think I can mention. Another aspect is the availability of research capacity for the high courts, as well as for the lower courts. The magistracy leaves a lot to be desired. Gauteng, at any given point in time, has a total complement of some 85 judges. Each division has 6 researchers at its disposal. That's woefully inadequate to assist with the research needs of judges. I'll mention those two for the moment, Deputy President.
And I would guess one could even add that, especially seen against the backdrop of the workload and the extent of the litigation that goes on in that division.
Correct. Correct. We are bombarded. There are counsel who sit in this room today who are complicit in that mischief, if I may use that word, of forever bombarding that court with complex and involved special motions, which we have bent over backwards to accommodate. Usually, they request full courts to hear those matters because of the importance they see in them. So yes, that is correct. The Gauteng division, especially Pretoria, is a very busy court.
I suppose we can forgive them on the understanding that their clients are only exercising their right of access to courts.
Correctly, Deputy President, and I always say to them, bring it on.
Thank you. In 2005, you were appointed as a judge of appeal at the SCA and left that court in 2010.
That is correct, Deputy President.
Some would be tempted to say that you left the SCA because you couldn't put up with the challenges facing that court at the time, that have been dominating the news in the recent past, especially before this body. So you didn't have the energy to be an instrument of the change now experienced in that court.
Well, I haven't heard that being said to me. I mean, what was said to me was an expression of surprise that one would leave a higher position for a lower position, because the position of Justice of the Supreme Court of Appeal is higher than that of a Judge President. And that's the one I've heard. I've not heard the one about me running away, so to speak. I wasn't running away. Yes, I had my fair share of the challenges that were happening there, and I'm one of those judges in that court, though viewed as junior, who took the fight to the seniors, who were in my space not behaving properly.
I have had the benefit of reading your judgments that form part of the bundle that you submitted. But I'm interested in the one judgment at page 40 of Book 1 of 1 for those who have hard copies. The case of State versus Crossbeck. Yours, you wrote a judgment in that matter?
The minority judgment, that's correct.
Yes, and it was yourself in the minority versus 4 of your colleagues. And they took the view that in your judgment, you didn't properly evaluate the evidence and in fact arrived at your conclusion on the facts not borne out by the record. What do you say to that?
Well, I don't agree with it. I mean, as I say, I think in my questionnaire, for the benefit of those commissioners, this is the so-called baboon shooting case that happened in the Northern Province or in Limpopo as we speak. There was eyewitness evidence of someone who was not more than 6 meters away from the shooter. And the majority sought to refuse to accept his eyewitness testimony, which was direct of how the farmer shot at them, based on him having been contradicted on an unrelated aspect of his evidence. And I found that not acceptable. And further, I just felt that the majority didn't factor in properly what I would call victim justice. This is a man who was shot by someone who says he was shooting at a troop of baboons. There was no evidence that there were baboons there. There were humans there. And that's what fortified my view in dissenting against a very strong-minded bench of senior colleagues.
Thank you. But you would accept the general proposition that appellate courts decide appeals on the basis of what is contained in the record, and that barring the admission of new evidence on appeal, they cannot stray beyond the confines of the record.
That is correct. I don't think that arose in that matter.
there is a phenomenon which I observed sitting as a judge of appeal in matters that came from the Gauteng division. And it is this: applications for leave to appeal for some reason take too long to be heard. You would have a situation where a judgment is given, say, on the 3rd of October. An application for leave to appeal is filed on the, I beg your pardon, I meant to say 3rd of February. An application for leave to appeal is filed on the 20th of February, and only for the application for leave to appeal to be heard 6-8 months down the line. And to compound issues, a judgment to be rendered a month or so later. Do you think that that situation is, or is it not undesirable?
Oh, it is very undesirable. I agree with you, Deputy President. And it is something that we speak about in judges' meetings all the time, that an application for leave to appeal must be treated like an urgent application. There are a number of factors that cause that, but there's no excuse. You are correct. It's unacceptable. And I could say that since the advent of case lines, that situation has improved drastically.
Because I recall from my days when I had the privilege to lead the Mtada division of the High Court, where I put in place a practice in terms of which, practitioners would approach the judge against whose judgment they seek leave to appeal, arrange dates, and the judge should then give priority to the matter. As you have said, even if you are sitting in the criminal court, you make a special dispensation where perhaps you would hear the application at 8:30 or 9:30 before you proceed to your other business for the day.
That is correct. I mean, as I said, one of the major contributory reasons for those delays you have sketched, Deputy President, was that the applications themselves were not sent to the judges directly. They go via the registrar's office. And usually from the registrar's office to the judge, there are always delays. But you're correct. It's an unacceptable situation, and I want to believe we've taken steps to remedy that situation.
Would that perhaps, or the fact that in some divisions, practitioners are not allowed easy access to the judges to say, here's the application for leave to appeal, here's the file, please give us a date. Everything is expected to come through the registrar.
That is the case flow management capacity that's put to support the judiciary. I'm not sure that judges would be able to cope with the traffic in terms of applications of that nature and other matters that they deal with if they went straight to them. I think the registrar's offices are created for a reason, and it is understandable that there needs to be efficiencies and courage in the registrar's offices to ensure that when they receive applications for leave to appeal, they alert the judges concerned without delay.
Thank you. Judge President Mlambo, at this stage, I'm going to afford you half an hour to tell the Commission and the nation at large how you see the role of the Chief Justice in a constitutional democracy, and also share with the members of this Commission your vision of a functional, efficient, accountable, and independent judiciary in the Republic of South Africa. Thank you.
Thank you very much, Deputy President. I'll try to keep to the 30 minutes, but I don't know if I will be able to. Thank you very much for the opportunity to share my vision as a candidate interviewed to occupy the position of Chief Justice. What I did in crafting my vision, members of the Commission, is that I considered what is the proper location of the judiciary in South Africa as a constitutional democracy, as well as the role of the Constitution in that regard, and, importantly, the role of the Chief Justice. I also looked at the current context that's prevailing in South Africa as to the judiciary, what is happening around the judiciary. I did that because it is important if one looks at Chapter 8 of the Constitution, where you find 165, Section 165, which tells us that the judicial authority of the Republic of South Africa is vested in the courts. But importantly, Section 1656, which charts the responsibility of the Chief Justice in terms of the establishment, monitoring norms and standards in the judiciary. So if I am appointed as Chief Justice, I will ensure that this reality that is sketched by Chapter 8 is put central to our efforts as members of the judiciary. The other aspect that I looked at before crafting my context, my vision, Deputy President, is that I conducted an environmental scan of what is the context the judiciary finds itself in. One of the aspects that stands out is that the South African judiciary is a functional judiciary. It's a judiciary that has lived up to the promise of the Constitution in terms of delivering justice. I'm proud to have been a member of this judiciary for just over 20 years. That's on the positive side, Deputy President. But there are challenges. That environmental scan, just to mention one or two aspects, informed me that there are perceptions around South African society that the Constitution has not delivered and is not achieving its purpose. My scan told me that there's loss of confidence in the judiciary, loss of confidence as well as in the justice system and the rule of law as sketched by the Constitution. But more worrying, Deputy President, my scan revealed that the judiciary operates in a somewhat toxic environment. Toxic in the sense that the judiciary is attacked on a number of fronts. Its independence and impartiality are always at stake and attacked. And this is the function of a polarized political space. You also have unfounded claims of corruption against members of the judiciary. But more worrying, members of the Commission, is that I can tell you as head of a court, starting in Labour Court and the High Court, that there is corruption growing involving court operations in South Africa. Corruption not by judicial officers, I want to state that upfront, but corruption in terms of the usage and the circulation of fraudulent court orders, which bear all the resemblance of a proper court order, but when you investigate it, you find that no such matter was heard on a particular date. That's an issue that I think requires serious attention because it can erode the legitimacy of the judiciary. We've mentioned increasing caseloads, but I think access to justice, access to courts remains an issue, despite us having got more than 20 years in our constitutional democracy. Those are just a few of the issues I thought let me mention that underscore the vision that I have crafted for the judiciary. And that vision, if I could mention it or express it in a sentence, is my vision is to see and have an efficient and effective judiciary that is independent and able to fulfill its mandate as set out in the Constitution. That's, in a broad nut, my vision. But this vision is underscored by pillars. I've come up with 7 pillars that underscore this vision to make sure that it succeeds. The first pillar is an effective and visible leadership, which we have spoken about. Effective leadership, members of the Commission, translates into a leader leading by example. A leader being with the judges, being concerned with their welfare and well-being. It is my aim that should I be appointed as Chief Justice, I will expand my efforts to make sure that together with the colleagues in the heads of courts and the judges that we lead and the magistracy, that we continue to fortify the strength and independence of our judiciary. As leader of a judiciary, I should be able to inspire and motivate and ensure that judges and magistrates deliver on the mandate that they have from the Constitution that we find in Chapter 8. And I will ensure that we build strong accountable measures to make sure that we account for what we do in the judiciary. My personal leadership style attests to this, and I can expand on it when I'm given time later. One aspect that I want to underscore in this pillar is that as a judiciary, we must find each other. I use that term deliberately to say we had judicial colloquia in the early stages of our democracy. I've been a JP since 2010. We've not had a judicial colloquium. We tried some 2 or 3 years ago to ask for a judicial colloquium to be held, to be convened. It is important as members of the judiciary and the leadership to convene in a colloquium, a judicial colloquium, to embrace the developments that happened in 2013 when the Office of the Chief Justice was created as a government department. What that entails. There are a number of other issues that we need to discuss as a judiciary so that we understand we are members of the same institution. One simple issue is the judiciary logo. The Constitution uses its own logo. The High Courts use a logo that was adopted by the heads of courts, but there are other courts that continue to use the executive logo. It's a simple issue that I just thought I mentioned, but it's one issue that needs to feature in the agenda of that colloquium. That's the first pillar, leadership. The second pillar, members of the Commission, is to, as head of the judiciary, to assert the rightful place of an independent judiciary as an essential arm of government. No doubt about it. We are the third arm of government. We are essential for this democracy. In line with that assertion, we as a judiciary and as head of the judiciary, I need to ensure that we develop strategies that are aimed at protecting our legitimacy as a judiciary and countering the threats to our legitimacy. As I've said, Section 165 should be our lodestar in this regard. One issue that I think is important in the assertion of the right place of the judiciary as an arm of government is to work towards encouraging the other leaders of government, the leadership of Parliament, the Speaker, and the leader of the executive, the President, and myself, if appointed as leader of the judiciary, to get together and talk about issues of concern or that could improve how things happen in our respective areas, and to express issues of concern that are maybe happening in the other arms of government that affect us as a judiciary. It is important that engagement happens on a regular basis. When I say regular, it could be either annually and sometimes when there are pressing issues to be convened to discuss whatever those pressing issues are. That's my second pillar. My third pillar that informs my vision, members of the Commission, is to go back and retake the discussions regarding the institutional model of judicial governance that was adapted for the South African judiciary. In 2013, when the Office of the Chief Justice was established as a government department, that was phase one of that model that we, as heads of courts, have adopted and accepted and informed the executive as such. There are two other phases that remain outstanding. The second phase is what I will encourage and initiate discussions on with the executive to say it is time that we look at taking the judiciary further towards total independence. Phase two in that institutional model envisages a judiciary running as a separate, completely independent entity with its own staffing, its own policies, and its own processes and procedures. And the example given in that model is that of the Office of the Attorney General. That operates on its own without interference by anyone else. That's phase two, and I will expend my efforts at making sure that we discuss and find ways to put that on track, because we are only in phase one. We still have a lot of things that are not happening within the judicial space that are happening elsewhere. And of course, some of them are countenanced in the Constitution. One key component of dealing with the institutional model is taking on hand the single judiciary concept. Office of the Chief Justice is in charge of the higher judiciary. The magistrates remain outside. The Constitution is clear that the Chief Justice is the head of all courts. And by all courts, it means all courts. I'll go to my next pillar without wasting any time, members of the Commission. And that pillar focuses on taking a serious look at improving and introducing efficiency measures in our judicial operations. And when I talk about judicial operations, I've separated into two. Judicial operations will be our operational workings in terms of the support structures headed by the Secretary General. That's a key component to ensuring that the judiciary delivers on the mandate of the Constitution and is efficient. There are a number of issues about that I will deal with, but let me just move on to the second part of this leg of improving judicial operations, and that's guarding and ensuring that there's continued improvement and working towards jurisprudential excellence. South Africa, especially our Constitutional Court, is renowned internationally, and its judgments are quoted and cited and followed internationally and on the continent. We need to make sure that that jurisprudential excellence continues. But a key factor in that is to ensure that our jurisprudential developments factor in our socio-economic realities. I mentioned in my context environment scan that there are concerns that the Constitution has not delivered, that the courts have not pronounced enough socio-economic relief for South Africans. It's an important factor to take up. In terms of ensuring that there's jurisprudential excellence, members of the Commission, it is key for the leader of the institution, and if I'm appointed as Chief Justice, I will ensure that there's continued capacitation of the intellectual capital of the judiciary. And that happens on a number of fronts, but the most important is continuous and continued judicial education, as well as continuous and continued interaction with other members of the judiciary in the continent and internationally. I think to ensure that the jurisprudence of our courts is properly focused on the South African realities, there is a case to be made for the judiciary to convene what I would loosely call a biannual constitutional law jurisprudential conference, where legal scholars, justices, international commentators, and members of society, as represented by grassroots movement, come and talk and chat and conduct a critical assessment of the jurisprudence of the courts, especially our Constitutional Court as the apex court. Access to justice should also feature. We've had a number of access to justice conferences. It remains a problem. One issue that I did as Judge President in terms of trying to improve access to justice is to establish legal access help desks in the labor courts and in the high courts. These assist unrepresented litigants who are hauled before the courts. They come without lawyers, they leave with lawyers. Let me come to the second leg, which is the operational efficiency of the judiciary. We touched on the proper resourcing and capacitation of the judiciary, so I won't go to it. The only aspect I want to mention there, members of the Commission, is the executive is always cutting budgets. Budget cuts have a detrimental effect in the judicial space because it affects key stakeholders like Legal Aid South Africa and members of the prosecution, because their human capital is reduced and their ability to cover the current courts and more courts is compromised. And this is a result of budget cuts. I think there needs to be a rethink. I know that the executive has been kind in terms of treating the economic space entities with kid gloves when it comes to resourcing. But I think it's high time they also factored in the judiciary and the justice sector at large, because we play a critical role in terms of our constitution. The issue of capacitation we've dealt with, but I think members of the Commission, as part of this leg, it is important that as head of the court and as Chief Justice, I look at particular functions and challenges regarding the operational efficiencies that we find in the justice system. The workings of the Constitutional Court, the workings, especially the complaint about the Constitutional Court taking time in terms of delivering its judgments. I think that needs to be looked at. It needs to be addressed. I'll come back to it. But as part of this leg, as head of the judiciary, if I'm appointed, is to reinforce oversight and accountability. And I mentioned oversight and accountability in one large respect. I've mentioned the issue of the Constitutional Court and judgments, but the delivery of judgments is a problem overall. If you look at the Judiciary Annual Report, you'll find seriously worrying stories of judges sometimes reserving for 2 years or longer. That's unacceptable. There needs to be consequent management. If you're appointed as a judge, this commission believes you are confident, it's confident you'll do your work. If you can't write judgments, you don't belong in the judicial space. That's my philosophy. One other aspect in terms one, I will expand my efforts from a good governance and oversight point of view is the issue of processing of judicial complaints. Judicial complaints have on occasion taken far too long to be processed. And this has led to the perception that we are hard on litigants and treat ourselves with kid gloves. That needs to be addressed. And one other aspect is to relook the capacitation of the JSC Secretariat. Is it properly resourced? Is it properly able to follow up on all complaints it handles? But more, to look at the judges who serve in the Judicial Conduct Committee. That committee of the JSC uses almost exclusively judges in active service. These are judges who have their own loads in their own courts. They don't have any special dispensation that gives them time to attend to JCC work. I think we need to look at that. In terms of accountability, I want to say as Chief Justice, I'll focus my efforts on looking at the workings of the justice system in particular. And I want to focus on 3 issues here, still part of this list. One of those issues is there are worrying levels of part-head matters involving awaiting trial detainees that take just too long to be finalized. These are people who've not been found guilty, but they languish in jail, sometimes more than 5 years, 6 years, 7 years. It is unacceptable in a constitutional democracy to have matters taking that long of people who are presumed innocent. That problem results largely in the regional courts. And I think as head of the judiciary, if I am appointed, it is an aspect that I will ensure I take on board and address. The issue of the Land Claims Court. The Land Claims Court is a constitutional court, a post-constitutional democracy court. But for many years, that court has operated with acting judges. And it is a court that does its operations more outside in terms of interacting with communities, especially. It takes a long time for a land claims court matter to be finalized. And it's no fault of the judges and the acting judge president of that court. It is the resourcing. That court needs more judges. So I applaud the recent effort of appointing judges, permanent judges to that court. It will go a long way towards addressing that. One last issue on this leg that I want to mention is our ineffective maintenance court system in South Africa. You talk to anyone, you listen to radio stations, you read horror stories about how single mothers in particular are unable to get maintenance courts to come to their assistance and bring up their children. It's a big problem that I will, as head of court, look at. There are issues about infrastructure maintenance. The Palm Ridge Court is falling apart. It's a new court. The Polokwane Court, High Court, that is the Limpopo High Court, is falling apart. It's a new court. Same goes for the Mpumalanga High Court. They are falling apart, yet they are new courts, because there are no maintenance contracts. Why should that situation persist? As head of court, I will ensure that when I engage the other arms of government, especially the executive, that they take this one up. The Soweto Court, or Potria Court, magistrates are working on top of each other because there's just no space there. It's an aspect that needs to be attended to without delay. The issue is about finding land. It's a to-in and fro-ing between the City Council, the Department of Public Works, and it's just going nowhere. These are real issues that needs to be addressed to make sure that we protect our space. My fifth leg or pillar of my vision is the establishment or development, let me put it that way, of a holistic transformative program for the judiciary. We need at a national level in the judiciary to have the same objectives as a judiciary about how we can achieve the transformation goals about obtaining, maintaining, and achieving demographic representation in our ranks. That's one issue I will focus my attention on. We need to develop a judiciary-wide gender-based violence, sexual harassment policy. In Gauteng, we adopted a sexual harassment policy, but we need a policy for the entire judiciary to make sure that we effectively deal with this scourge. There's also an issue of looking at internal institutional health issues, like the well-being of judges, the issue of medical aid and stuff. There's an issue there that needs to be addressed. The sixth and second last pillar is to develop functional communication and engagement strategies as an institution. We have a policy in the judiciary, and I have no reason to doubt its efficacy. All that requires is that we, as heads of courts in particular, need to make sure that we apply our communications policy. I chair the Judicial Communications Committee of the judiciary. That's why I am the editor of the judiciary newsletter. But it is critical that we have a properly placed communications platform that enables us to be timeously responsive to attacks that come against us. And that policy sets out all the functionaries of there, with the anchor position being that of a spokesperson, a judiciary spokesperson. So we can talk further about the other legs of that judicial policy. But I think it is important that we are able to communicate effectively our messages, our judgments, and to dispel whatever perceptions are there in terms of what we do as a judiciary, to make sure that South African society is informed about what we're doing. I think this is where the importance of a structured engagement with the arms of state comes in. Because sometimes issues erupt in the public domain that affect us. And it is important that when we come together as leadership of the three arms, we're able to deal with these issues. But there's an important other aspect about that gathering. Chief Justice Mogoeng established the PECs and NEEC. The NEEC, which is the National Efficiency Enhancement Committee, it brings together national leadership of key government departments and judiciary stakeholders, as well as leadership in the judiciary. It is at that forum that implementation failures down are escalated to make sure that the NEC looks at the national leadership that's there and identifies which departments are not delivering and why they're not delivering, and put them on terms to do what they're supposed to be doing. I mentioned the issue of maintenance contracts. It is unconscionable that government would spend so much money in building new court infrastructure and also see it deteriorating. So implementation failures that can be resolved at the NEE level can be adequately dealt with in the meeting of the leadership of the three arms of government. My last leg of my vision, members of the Commission, involves embracing and continuing to embrace innovation and court modernization. And the sub-part of that is ensuring that we are administratively efficient as a judiciary. We have all seen that properly taken advantage of, technology can go a long way in enabling us to be an efficient judiciary. And I thank Chief Justice Mogoeng for conscientizing all of us as heads of courts that we need to take on board modernization. I mentioned case lines. Case lines is the buzzword in Gauteng. Unfortunately, it has not been cascaded to the other divisions, and it's through no fault on my part in particular. It's something that can be discussed, but as I sit here, I'm acting the Constitutional Court. The first thing I did was to ask permission from the acting Chief Justice that he allows me to use case lines. Because I'm used to it. I can't go back to hard copy stuff when I know that there's a platform that's hugely enabling in terms of making sure that everything is available on my fingertips. We are about to have the implementation of what we call Court Online. Case Lines is an evidence management platform. It was meant for that, conceived for that. But because Court Online, which is the CRM Dynamics platform under Microsoft, has been long in coming along. It's taken a long time, but it's imminent now to be implemented. That's the e-filing system that will deal with the proper e-filing of pleadings that will then be embedded onto the Case Lines platform. So these two programs are the reality for the South African judiciary as we go on. And I will ensure, if I'm appointed, that I continue to champion the usage and the embracement of IT. One key and very critical element in terms of ensuring that members of the judiciary and the legal profession embrace technology is what is called a change management tactic, is to have a champion. As Chief Justice, if I'm appointed, I undertake to ensure that I champion modernization in the judiciary, not only championing it by talking, but by using it. It is very important because when judges see other judges doing it, that's how we introduce case lines. We started with 5 judges. It increased until it was accepted by all judges that this is the way to go. One other aspect, which is the last aspect on this leg, members of the commission, and I'm sort of taken long, is the judiciary is the custodian of old court records. When we had a presentation from an official of the Department of Justice some 5 years ago, he told us that what the Department of Justice was in custody of in terms of old court records from the judiciary was files and court records that could fill 5 rugby stadiums. Some people were laughing at the Gauteng High Court when there was rains and there was flooding in the courts and a lot of files were flooded. We don't need to experience that heartache. We need to digitize those court files. Once you digitize them, they are available on your fingerprints, and you don't need any physical space that you pay money for to maintain. When we visited Brazil, myself and Chief Justice Mogoeng and President Maya, I took it upon myself to go and explore how they digitized their records. It took them a full 2 years. And what they did, they approached entities that were responsible for taking care of the interests of persons with disabilities. And they used them largely to digitize the entire Brazilian judiciary. So, members of the commission, modernization is the way to go. You can call me a judicial technocrat if you want to, but I am as much a technocrat and administrator as I am a judge. I have sat in a number of cases, and I think I bring enough energy to make sure that these pillars of my vision go a long way into asserting the judiciary in its rightful place. I will stop there. Thank you very much.
Thank you, Judge President Mlambo. At this stage, I will call upon any of the members of the commission who would like to put questions to you to indicate to me. I'll record their names and thereafter give them an opportunity to ask whatever questions they might have, and in the order in which an interest has been indicated to me. Today, I want to give preference to our fellow commissioners who are with us virtually, if they would like to avail themselves of that opportunity. And that will be Commissioner Breitenbach and Commissioner Barnard.
Thank you very much, Deputy President. Mr. Barnard had his hand up before me, so I'll defer to him after a second. Thank you.
Thank you. Okay, I'll take the minister. Oh, by the way, I have to begin. Okay, Advocate Mbofu, Madonsela, Advocate Kane, Commissioner Tsepe, Commissioner Matolo Lepu, Commissioner Matolo Lepu, you will be number 8 today, not 17. Commissioner Shamuk, okay, thank you. Prof, I've noted you. Okay. Thank you, Commissioner Magwanisha. Okay, Commissioner Moimang. Commissioner Klaba, I've got you. Commissioner Nyambe, I've got you. Oh, Madam Speaker, Commissioner Mapisa Makula. I've noted you, Commissioner Malema, Commissioner Singh. Commissioner Dodovu and Commissioner Nakesi. Yeah. Okay, before I allow Commissioner Breitenbach, I just want to make one housekeeping announcement. There will be load shedding again today at 2 o'clock. So we will adjourn for lunch at 10 to 2. And then resume at 10 to 3. And we'll take a short adjournment again at 4 o'clock and resume at 4:30. Thank you. Commissioner Breitenbach.
Thank you, Deputy President. Good morning to everybody, and good morning to Judge President Mlambo.
Good morning, Commissioner.
I hope you're well.
Under the circumstances, I'm trying.
My first question, Judge President Mlambo, surrounds the Legal Aid Board of South Africa. So you were involved with that for over a decade, well over a decade, and you, when you took it over, it was really just, I hesitate to use the words dysfunctional, but it did not function well. It was not highly regarded. It struggled to attract staff of any description, let alone staff of good quality. And the work it produced was generally quite sharply criticized by the courts. And when you left it as running as a well-oiled machine, an employer of choice, attracting skilled practitioners, producing work of high quality, on time. The change around was quite remarkable. So my question is, the lessons that you learned at Legal Aid South Africa, how would you implement those to achieve the same kind of turnaround in the courts, which are not, not all the courts, but those courts are not functioning optimally, and particularly, how would you use your influence if you're appointed in the lower courts to make them more efficient? Thank you.
Thank you very much for the question, Commissioner Barnett. I mentioned that as Legal Aid Board Chair, we focused at the beginning of my tenure in 2002 at having a 3-day strategic session that considered what the environmental scan had produced about why the legal aid was not performing as expected. The biggest issue was instability at executive ranks, instability at lawyer ranks. Now, instability at lawyer ranks was because all the lawyers who were employed by Legal Aid South Africa at the time were on fixed-term contracts. And towards the end of their contracts, they got jittery feet. And when they left, that destabilized court roles. And we had to take a decisive policy decision that those contracts are going to no longer be fixed-term, but be permanent. But coupled with tough performance management policies to make sure that people don't relax because they're permanent. We also ensured that we stabilize the instability at executive ranks, that is the leadership at operations. And the team that started that journey saw the journey through, because we wanted buy-in to the policy of what the Constitution expects the legal aid service offering to provide in terms of quality and timeless assistance to people who needed assistance. So we also looked at the issue of resourcing, right? You look at the courts that you've got to service as an entity, and you make a judgment call as to how many lawyers you need to service each particular court. And you have to make sure that those lawyers are properly resourced, right? The problems of the past were that lawyers were carrying unrealistic caseloads. They had no preparation time, no consultation time. We looked at all those things to ensure that we bring in timely interventions to give them that space, that when they appear, they are properly prepared. So that's at the top, that's what we did. But in terms of your second question, Commissioner Breitenbach, about the lower courts, I think a serious discussion needs to happen about the system that's followed, especially in the regional courts, criminal courts. The high courts use what we call a running roll system, where when you start a case, you must finish it. In the regional courts, you'll find on the roll of each magistrate on a daily basis, it's got 5 matters, they're all part-head. You'll hear 2 witnesses in one case, postpone it for another month or 2 months, hear another one, do the same thing. And that's what adds to these matters not being finalized timeously. I think we need to consider seriously, as a leadership of the judiciary, strong case management initiatives at that level, as well as looking at the system the systems that are used by those courts in terms of ensuring that when they start cases, they run them and finalize them. So let me stop there. I hope I've answered your question partially, or if not fully.
Thank you, JP. You've answered my question fully. Thank you very much. My second question is about how you would, if you're appointed, what do you see as the most appropriate method for the judiciary to provide comprehensive feedback and interaction with Parliament and with the public with regards to judicial accountability? Thank you.
Well, I mean, there was a reason why Chief Justice Mogoeng, with the agreement of the heads of courts, adopted the Judiciary Day, Judiciary Annual Day initiative, because we use that day annually to account to the South African public about judicial operations in terms of judicial functions. Because I'm not aware that we have an obligation to account to Parliament as a judiciary for judicial functions. But we have also, as heads of courts, met with the Justice Portfolio Committee, because it's a committee that operates in our space. And it's, to me, an inter-branch engagement between the judiciary and the executive in terms of sharing points about what's not going right, what's going right, and ensuring that the service offering improves. In terms of operations, in terms of how the budget is spent, the human capital, how people are employed, dismissed, and other aspects about that, the Minister of Justice currently accounts to that for the Office of the Chief Justice, and that's part of the phase 1 process that I mentioned. But I think for judicial functions, because I'm sure that's where your questions is focused at, is I think the current annual Judiciary Day is sufficient to tell South African society how we have done, how many judgments how many cases we've taken on board, how many cases we've finalized, how many judgments are reserved, how long they took, and things like that. So I think those processes are enough. They just need to be buttressed to make sure that they continue to deliver. Thank you.
Thank you very much, JP. Thank you, Deputy President. Those are my questions.
Thank you, Commissioner Breitenbach. Judge President Mlambo, I've got Commissioner Lucas, who has a follow-up question on the questions posed to you by Commissioner Breitenbach.
I also have a follow-up, Acting President Lamola.
Noted, Honorable Minister.
Thank you very much, Acting President. Good morning, JP.
Good morning, Commissioner.
Yeah, it's a bit strange to see you on the other side of the table. But no, you were speaking about the annual Judicial Day as like a kind of a feedback to South Africans. I was just wondering, do you really think it is inclusive enough to make sure that there is a better understanding of the kind of load or the kind of responsibility that is being carried by the judiciary. It just came up in my mind when you said it seems to be sufficient. I mean, we can differ about it, but do you really truly think it's inclusive enough, yes, particularly of the lower levels, to make sure that there is a better understanding?
In fact, that's an important question, and thank you very much, Commissioner Lucas, about that. Because I think in one of the pillars, the communication pillar that I elaborated on, one of the aspects I didn't mention was that as a judiciary, and it's part of my psyche, so to speak, that we need to stay in touch with South African society. So that's one level at which we account to South African judiciary. But in my pillar, I've sketched that there's a case to be made for grassroots organizations that represent larger South African society to be consulted or to be organized in an engagement where I've seen the Department of Justice called the Imbizos, you know. There's nothing that would preclude the judiciary to hold an Imbizo and to hear from members of the public what their concerns are and to clarify what they have issues with. I think that would go a long way in terms of making South African society understand judicial operations. So yes, it may not be adequate sufficiently, but we are there to listen as a judiciary to say what other improvement mechanisms can we embed to make sure that our accounting reaches a far bigger group. Thank you very much.
Thank you, Chief.
Thank you, Commissioner Lucas. Honorable Minister.
Thank you very much, Acting Judge President and JP Mlambo. Good morning. When you spoke about 7 pillars, I thought you would say 7 cardinal pillars. No, but I think you deliberately said 7 pillars. My question relates to the first one on the legal aid that Commissioner Bradenbach has asked you about. I've seen that within the justice family, legal aid is also one of the most techno-savvy or digital kind of use of platforms. Did you play any role there when you were with the legal aid to transform them or to help them transform in the use of these digital platforms? I've heard you speaking, when you were speaking on you only spoke about your role on case line and in Gauteng. Did you play any role in the legal aid in that regard?
Oh yes, Minister, thanks for the question. We, in our strategic planning session was to specially find funds in our budget to initiate a process, a product called Ad Infinitum, AI. That was a technological initiative that would help legal aid in terms of tracking from the time a file is opened and up to its finalization. Because you'll remember one of the complaints was that legal aid is taking too long in terms of finalizing cases. So AI was meant to deal with the operations of on the legal side of things, as well as help with management information. Because it is important to draw reports from technological products that inform you which other improvements we can make. Yes, I was involved because I was chairing the board when this whole issue was decided, and we decided as a board that it was an important strategic direction to adopt to make sure that Legal Aid South Africa is technologically enabled to make sure that it does its work much more efficiently. Yes, I was involved. Thank you for that question, Minister. In fact, that's where, those days, I'm sorry to say this, 2002, 2003, 2004, I was in the High Court and transiting to the SCA. The Justice email platform was notoriously unstable. For me to make sure I continue doing my work, I used the Legal Aid platform. And I'm just giving you that example to say we understood the role that can be played by technology in introducing efficiencies. And ad infinitum, yes, is the product that we helped. I think it was changed when a new system was adopted after I left Legal Aid South Africa in I can't remember, 2017 or 2019.
Thank you, Acting President.
Thank you, Honorable Minister. Commissioner Barnard, do you also have questions for Judge President Mlambo?
Good morning, Acting President and fellow Commissioners and President Mlambo. Yes, I do. I would like to put my questions now, if it's possible.
Yes, this is your moment then. Thank you.
Thank you very much. Judge Mlambo, before I heard your vision, that slightly changed my reading of the preparation time. But one of the things that came to me strong to the fore, not only just in preparing on the documents, but in the interactions with yourself in the past, is that one word that comes to mind strong is delegation or empowering. You have a way of empowering and building or using or assisting people around you to actually carry the vision forward. Now, one thing that has been made, one point over the past couple of days, is that the task of the Chief Justice, the Office of the Chief Justice, is huge. How will you use this to your best, this attribute of yourself to your best? The delegation and empowering of people to assist with carrying the vision forward.
Thank you very much for that question, Commissioner Barnard. I think it's part of my psyche. I humble myself. I'm one head of court who's acutely aware that there are some of my judges who may be better than me in one or other aspect. Instead of sidelining them, I bring them closer to me because I believe we are colleagues. We're both betting for the same team to make sure that the team succeeds, it's productive, it's efficient. So that's one of my leadership traits, to bring anyone on board and to take people with me on board. All my directives that were issued when the pandemic struck were not dictated to judges or the profession. They were done in consultation with the judges and the legal profession. That's what I can cite as me taking people along with me, because in those engagements, we debate and understand why we want to go a particular route. But an important aspect, Commissioner Barnard, is I was aware that the resourcing and the capacitation and around the judge president needed attention, because if you only have one secretary and you have a lot of things that you have to do as a judge president, you need proper support. I came up with the idea of office managers in the office of the judge president. That office came about after I took over and I suggested it. And I know that there are heads of courts who have taken it on board and use it, because it is an office manager who also deals with the issues that judges are faced with. One thing that I believe in is judges must work in an administratively efficient environment. They don't have to be bogged down by administrative issues. That's my task as their leader, to make sure that I deal with the administration issues that may be at their issues. So that's my way of doing things, of making sure that people follow me, understand me, persuade me, and we go along in the route that we've adopted. Thank you for the question.
Thank you. Now, when in listening to your very positive vision, specifically the aspect on modernization, it really, I think, is something which comes across well. Now, the question is, how practical is this? I'm actually asking your vision for hope almost, because, you know, it's one thing having the rollout in Gauteng, but if one, as myself, practices quite often in the magistrates court, and one sees the lack of capacity on the side of, for example, the court function, you know, the clerks of the court and that sort of thing. So there's a huge gap between, or disparity between, I almost want to say those people serving the high courts and maybe the magistrates courts in providing support functions. So can you give us hope that this vision of yours of modernization can be carried through to the courts at that level?
By all means, I can give that undertaking, and it's one of the objectives I will pursue should I be appointed as Chief Justice. The points you mentioned about the magistracy are points that are very critical and important and affect the service offering from that level. Had it been for me, I would have ensured that case lines is also, as it is currently operational in Gauteng, it also is operationalized in the magistrates court. I mean, as we speak, the issue of dealing with criminal trial records that are on appeal in the High Court, those records are available electronically in the magistrates courts. But because of the thinking, the static thinking that's there, these are downloaded and printed and then sent to the High Court in hard format. That's not adequate. What should be happening is, and I requested the regional head here to say, the court clerks must be trained on how to upload those records onto case lines. And voila, you have it in front of you if you're sitting in an appeal. So, and I can mention this, some people may be angry with me. There are magistrates that have acted in the High Court and that have tasted and used case lines. I have some of them who phoned me to say they've sought agreement with the practitioners in matters they're involved in. They seek my permission to use case lines. And I've said yes, by all means, they should do it. Because it's a system where we use the public's funds to pay for. And it should be used and cascaded as widely as possible. Thank you very much, Mr. Barnett. I hope I've answered your question.
Yes, thank you. Now, going even lower, what would your vision be to, you spoke about courts being all courts, quite correctly so, in terms of 166, and then specifically thinking about the other courts, 166E, what's your vision for something like the small claims court, for example?
I think the all courts caption means all courts. The small claims courts, I mean, I've attended a number of functions organized by the Deputy Minister of Justice, who takes particular charge of those courts. And my sense was that there's huge commitment from members of the legal profession in serving as small claims court commissioners. And I think, if I'm not mistaken, the jurisdiction of the small claims court has been increased to countenance a number of the matters that would force people not to litigate because all their capital will be taken up in lawyers' fees. So that's a positive example. But there was an issue about small claims court not sitting only in the evenings or at night, but sitting during the day. I think it's a worthwhile argument and initiative to be embraced to make sure that they continue serving. Because I know from where I sit, based on those functions that I've attended, that they bring justice to the grassroots levels of society without them having to spend a lot of money. So it's something that we should look at as members of the judiciary, and in consultation and discussions with the member of the executive in charge of the justice portfolio to see how it can be buttressed and influenced and improved further. Thank you, Commissioner Barnett.
Thank you. Now, just moving from that to much on the vision aspect, you've spoken much about South African courts, but on the matter of the SADC tribunal, you know, the tribunal that's seated in Namibia, and the litigation that took place there and so on. Is there a role, and what is the extended role for a court such as that in the Southern African system? How do you see that as part of the judiciary? Or specifically because that matter originated or was litigated in your court and so on as well?
Yes. Thank you for the question, Commissioner Barnett. The SADC Tribunal is a regional court. It was meant to serve the SADC member states and the citizens of those member states, right? So regional tribunals operate on what we call a complementary jurisdictional premise. Complementary in the sense that if you do not get justice, in the sense that your matter, your local or domestic justice institutions don't want to hear your matter, then that triggers the jurisdiction of the regional tribunal to hear your matter. That was the case regarding the SADC tribunal matter I was involved in. The farmers whose farms were impounded were not getting justice in Zimbabwe because the Zimbabwe courts didn't want to hear their matters, and they went to the SADC tribunal. And when the SADC tribunal made its findings and rulings and ruled against the government of Zimbabwe, that was followed by an AU or SADC leaders meeting that worked towards disabling that court from doing anything further. So I'm saying the regional tribunals are international tribunals. They exist like the African Court on Human and People's Rights. They exist to provide justice to those citizens of the member states who haven't got justice in their own domestic backgrounds. So yes, I mean, I would encourage that we continue supporting that initiative of the SADC Tribunal and the African Court on Human and People's Rights. I think Advocate Nsebenza is one of the most recent appointees to that court. So we should, as a country, support these international tribunals, especially in the continent.
Do you think, and it doesn't have that role at the moment, but do you think it has a role to play, or one could develop it into a role? I'm thinking a situation like we faced in South Africa over the past many years, where there's a crisis in the judiciary. Maybe a judge is, there's problems with a judge or whatever, and then the matters are litigated up to the Constitutional Court, and you sit with all sorts of questions like judges should recuse themselves and that sort of thing. Whereas couldn't it be of assistance that one could have even another court to refer such matters to have more of an independent view taken? I know this is a big jurisdictional issue, but just thinking visionary now, is there not some way that could be developed in that direction, or movement in that direction?
Well, thanks for the question, Advocate Mr. Barnett. I think it's an issue to be considered, but from where I sit, I've been involved in requests from other jurisdictions on the continent, especially in Lesotho, where members of the Lesotho judiciary cannot sit in a particular matter, where South African judges are requested. I mean, they would ask for judges from Gauteng or from the Free State. I'm not sure if JP Musi has participated, but I suspect he has, in going to those jurisdictions to deal with those matters. I think, in my view, it's a much more cleaner way to source the judicial capacity elsewhere, but not fiddle with the jurisdiction of the domestic of the regional tribunals, because those operate in a carefully circumscribed jurisdictional space. And I don't think these would be the type of matters that would go there. That's my honest answer.
Thank you. Then my last question. We're sitting with, well, this is the third interview, but it seems apparent that there's 4 very strong candidates, each with maybe unique areas or reasons why they are best suited for the position of Chief Justice. But how do you think, having been serving on the JSC also for quite some time, how do you think the Commission should deal with the gender issue, bearing in mind that all candidates are strong and capable, etc.? What should the approach be?
I don't think the issue arises, Commissioner Barnett. I mean, if the question to me is South Africa ready? And I don't think why should one ask that question? Is South Africa ready for a female Chief Justice? We've been ready for a long time. It's not an issue. I think President Maya answered the question adequately yesterday by saying, you're not appointing me because I'm a woman. If you appoint me, you're appointing me because I'm a strong judge. I think that's the issue, isn't it? But talking about gender in general, I mentioned in one of my pillars that we need to have a holistic transformation agenda for the judiciary or program. At Legal Aid South Africa, one of our deliverable objectives was tracking how we were doing in terms of changing the demographics of Legal Aid South Africa. I'm proud that I was able to ensure that we appoint a female CEO and we appoint women in key aspects of the executive management of Legal Aid South Africa. The CFO was a woman. The head of IT was a woman. The head of the audit committee of the board was a woman. So I think I'm alive to these transformative ideals. And as Chief Justice, if I'm appointed, I'll ensure we have a transformative agenda that looks at gender transformation of the bench and that has realistic objectives from a timeline point of view to say by this time, this is what should have happened. Because as judge presidents, I've discovered that one can productively use available vacant judge positions in terms of bringing on women candidates to come and act. One of the members of the commission here heads an organization that had an undertaking, an understanding with me that at any given point in time, when I appoint acting judges, I must make sure that 4 of those women acting judges come from women and from that organization. And I want to believe I've lived up to that. My statistics at how I've done in that regard speak volumes. When I took over Gauteng, there were 49 male judges and 15 female judges. Today, we have 41 male judges and 38 female judges. I want to believe I've done my bit to advance gender transformation in the Gauteng bench. So yes, I will continue my efforts to make sure that. But I think a holistic program that has timelines is the way to go.
Thank you, JP. Thank you, Acting President, also for starting online today. We appreciate it.
Thank you, Commissioner Barnett. Members of the Commission, I propose to give the Honourable Minister an opportunity to put his questions, after which we'll take the short adjournment, which in fact we should have taken about 15 minutes ago. I hope you'll bear with me. Thank you. Honourable Minister.
Yeah, thank you very much, Acting President. And I have already greeted you, Judge President.
Indeed, Minister.
My question relates to the issues you raised in your vision on the court administration model and the office of the Chief Justice. What is your envisaged end goal of that office? As you are aware, it was a temporary arrangement, and I heard you saying it was phase 1 and so forth. What is your envisaged end goal? And do you think Section 54 of the Superior Courts Act, 54(1), I'm not sure if I should read it for you, or I suspect you will be aware, but it speaks about the role of the minister, particularly in Parliament, to request the fund. But it says that the Chief Justice determines the budget after consultation with the other heads of courts.
I think that's the current arrangement, Minister. And I did acknowledge when I articulated my vision about that there are provisions, even in the Constitution, that envisage a role for the executive in judicial affairs. So there's no debate between us about that. But the model that I articulated, that we as heads of courts looked at, is a model that envisages a journey to total judicial independence. You will recall that in that model, I think that comes in phase 2, to say the governance of the judiciary from an oversight and accountability point of view will be undertaken by a judicial council. A judicial council that involves the judiciary, it involves the executive, it involves the legal profession, involves members of society, it involves traditional leadership. So that's phase 2. I'm saying there's no reason why we as a judiciary should not engage with the executive to say, this is the model that we in the South African judiciary think it's the way to go. Let's talk about it. Because it's a platform where we'll exchange ideas and debate, right? If we are wrong, I'm sure the executive will be there to say you can't go this route for the following reasons. So yes, Minister, you're correct. Section 54, as you say, has a role for the executive in judicial affairs. Just as the role it is there for the appointment of judges and acting judges. It's a role that the executive plays. It's countenanced in the Constitution. So you say to me, what do I envisage? What will I do as Chief Justice? I've looked at this as work in progress. We gave the report to Minister Hadebe when he was the minister, and we say, this is what we think we need as a South African judiciary. Let's talk about it. That engagement is long overdue. That's what I was saying. And as Chief Justice, I'll ensure that that engagement starts and continues.
Yeah, no, thank you. I think the executive will also be ready soon to engage at that level. The response is being processed through cabinet to respond to that input. So hopefully we will engage soon. What is your view? I want to ask you with regards to the Section 29 of the Superior Courts Act. For sure you were watching yesterday.
No.
Oh, you did not. Okay. What is your view on the operationalization of Section 29 of the Superior Courts Act?
Would the minister just tell me what the section reads? I don't have the act with me.
The Rule 29 is the Chief Justice, after consultation with the minister, makes rules relating to the manner in which the Constitutional Court may be engaged in any matter, including the matters referred to in Section 172 of the Constitution, and all matters relating to the proceedings and before the court. You will be aware that we could not be able to operationalize this section because of the concerns that were still raised by the heads of courts through the former Chief Justice.
Yeah. Minister, this is one of the issues that need to be resolved, because at the heart of this problem is the rule-making prerogative that's involved there. And that's the prerogative of Parliament, isn't it? So my view as Chief Justice, let's engage, but I don't think we can completely oust the role of the executive in that, as long as it happens in consultation with us as the judiciary. I mean, that also deals with the issue regarding the Rules Board. I mean, the complaint has been the Rules Board sits in the executive, but it makes rules for the judiciary. The issue is consult us. Let's tell you what we think will work best. And then you can take it forward and then promulgate the rules. That would be my approach, simply put.
What do you think are the lessons you have learned when you played a role in the establishment of the Mpumalanga Division and the Limpopo one, in terms of access to justice, including your role as the chairperson of the Legal Aid South Africa, which is responsible mostly for access for the indigent people of the country?
I mean, from an umbrella position, if I may use that, it pained me that when I took over as JP of Gauteng, people in Limpopo came to Pretoria for their cases. And some people around Thohoyandou, because the Thohoyandou High Court only had jurisdiction for a very small area. Everything around that, everyone around that court had to come to Pretoria. With Mpumalanga, it was even worse because there was nothing. That's at the core of access to justice, Minister. When we say access to justice, bring the institutions of justice closer to the people. That's my principle, and that's why I worked hard at ensuring that those courts, like the Limpopo one, that had come to a standstill and nothing was happening, that it is, the process starts afresh and it continues. And that, as I say, in Mpumalanga, it existed as an idea. There was nothing when I took over as Judge President. But I made sure that what you see today happens, because it is in keeping with access to justice.
Yeah, lastly, continuing on the access one, you spoke about the issue of the use of technology for Legal Aid South Africa and also the Gauteng. How do you think access can be enhanced through technology? And what will be your role to ensure that technology, as you speak, can be something that it does not then also hinder access? As you are aware, our country, there is a technological divide.
Yes.
And the indigent people, for example, that are helped by Legal Aid South Africa may not have access to the SIM. How are you going to help us as you help with the modernization and so forth, that this also bring together or bring along the people that may be affected by digital non-access?
Yes. Minister, thank you for the question. It is a critical issue that when we move to the technological world, we do not leave anyone behind. The point you make is a very important point. I chair CAUSA, which is active in the grassroots level. We have advisor offices deep in communities, and communities know they can access legal assistance from these offices. When COVID struck, we sourced funds to provide data to our advisor offices, because data is the big issue when it comes to access to anything. We source funds for data and for laptops and tablets for our offices, but for them to also spread the message that they could assist members who come in terms of lodging whatever claims they wanted to lodge. So you are correct, Minister, that we need to be careful that as we move to the technological world, we don't leave anyone behind. In the high courts, I was alive to that reality. That's why I said, any person who comes to the court and the matter is being run virtually and on case lines, we've got help desks that are established in both courts to make sure that members of the public are assisted to participate in proceedings that involve them. It's an involved issue, but it's an issue that we need to make sure that we understand the dynamics of the communities that require these assistance, and how we can establish points of contact where they'll be able to, I mean, you'd call it hubs. We saw this when we went to Malaysia with former Chief Justice Mbuyiseli, where you'd have hubs that members of the public will know they'll go to if they want to lodge something or file something in the courts, and it will be received in the courts. So it's an engagement that has to happen so that we don't leave anyone behind and we understand those dynamics.
Judge President, with your indulgence, I have one last question I forgot.
Please fire ahead, the Honorable Minister.
Yeah, Legal Aid South Africa will soon be handling land matters. And I know you have dealt with the Legal Aid South Africa introducing many aspects of the law. What could be the lessons we can learn from that experience of introducing, and what should be your guidance to the state and to the courts, the Land Claims Court, as it will also be dealing with practitioners from Legal Aid South Africa now handling some of the land matters?
Yeah. Well, Minister, you would know that when I was still chairperson of Legal Aid South Africa, I began championing this cause that the model that the executive had of handling land claims court matters was seriously expensive at the time. And in discussions at portfolio committee meetings, we were able to demonstrate to them how, given the money, because it comes with money, you need new lawyers. You can't add the land claims court work on the current workloads of the people who are there. You need funds. And you need funds to employ legal practitioners that understand that area of the law. Because the dynamic as we speak in the land claims court scenario is that the landowners have got deep pockets. They are represented by well-oiled legal teams, but come to the communities. It's a problem. So those are the dynamics I was talking about, to say in these matters, if the land claims court head of court gets matters that involve communities that require assistance financially in terms of legal assistance, she should be able to make sure who she makes a call to. And if it goes to Legal Aid South Africa, adequate resourcing from that point of view is critical. Otherwise, it will flop.
Thank you, Acting Judge President.
Thank you, Honorable Minister. At this stage, we'll take our mid-morning adjournment and we'll resume. I make it 11 now on the dot, to resume at 11:20. Judge President Mlambo, you are also free to stretch your legs.
Thank you very much, Deputy President.
And good morning, Judge President Mlambo.
Good morning, my fellow Ghana.
Goodness. I must indicate from the beginning that I had an opportunity to serve with you, and you were my leader and Judge President at the Labour Courts. And I can attest to your leadership skills, particularly administratively and intellectually from the cases that we set on. And I must also indicate that you appear to be a bit modest in your CVs and information that you have provided. And the heads of the judges president, which I represent, do have confidence in you. And this is also evident from the fact that you have been deployed to serve to lead so many committees in the heads of court. And one wonders at times, where do you find this time being so overloaded by virtue of you leading the biggest and busiest court in the country and being able to perform your functions on those delegations that have been given to you quite well. But this brings me to the 7 priorities that you've mentioned. Firstly, I know you were instrumental in introducing the traditional courts to be part of the system and community courts to be included within the judicial system. And I would want you to say something on that. And then secondly, from the 7 priorities, are those that you would prioritize, I mean the pillars that you would prioritize as immediate and immediately achievable if you ascend to this office of Chief Justice?
Thank you very much, Judge President Tlaletsi. I think I must just own up the credit you give me regarding the traditional courts and community courts belongs to J.P. Legodi, I think.
Yes.
Not to me. I was part of the thinking process with him, but he was leading that aspect. But thank you for giving me that credit. I appreciate it. Your question is, which ones should I prioritize? I think the very first one that I mentioned, that looks at the institution of the judiciary, because it has in it embedded an engagement with the other leaders of the other arms of state. Just to lay the groundwork, I would prioritize that one up front, right? And then the issue around a holistic transformative program for the judiciary, it also requires prioritization, because as a judiciary, I think we've lagged behind in terms of keeping up with the promise of meeting the demographics as we have the Constitution. So I would put those 2 right up there, but probably something that also needs to be looked at is the issue of looking at introducing efficiencies in judicial operations. That is addressing the issue of reserve judgments, long processing of cases. So I think I would put those 3 up front. The others are not very far behind, but I think those 3 would require urgent attention. Because I think this one that I'm mentioning now, it has in it the issue of looking at the ideal efficiency that one looks for, especially in the Constitutional Court and in the other courts, in terms of receiving cases, what type of cases, and how long it takes for judgments to come out.
I see. And then please, on behalf of the JPs, how soon can we have a rollout of the case lines?
It should have happened in 2020, JP,
Yes.
Tsaletse, you know.
Yes.
And I was pushing for it, but it's a different story why it didn't happen.
I see, thank you. And then I've noticed from the comments by the GCB that you are a person who would also perform the functions, the core functions of a judge who is leading a division by sitting on cases. Some of them are high-profile cases, and you wouldn't shy away. You would sit with the other senior judges and lead them in those cases. But then, okay, you may comment for now.
Sorry. You were not finished. Sorry about it.
Yeah. Now, it would appear that participating again in those cases, it has led to an objection that we have before us, coming from the Office of the Public Protector, either in her personal both in her personal capacity and in her official capacity. Firstly, I do understand that there is no pending complaints before this body against you regarding those issues that have been raised. It is only here to serve merely as an objection to your appointment to this office. Would you like to share some information on that? I know you have provided a written document that's dealing with that.
Yes.
But for the benefit of the public, I don't want things to be spun and as if this was not attended to.
Yes. Yes, I think those complaints, if there are any complaints from the Office of the Public Protector, have not seen the light of day as far as the JSC and the JSCC are concerned. She's not done that. And as I've responded in my response, her first complaint that I refused to meet with her when she asked for a meeting, I've clearly explained. She had lawyers. She didn't use those lawyers to write to me. She wrote to me herself, saying she wants a meeting. And she explained why she wanted a meeting. I've mentioned in my response that there's a cardinal principle in how we engage with litigants as judges. She wanted to meet with me on her own and her staff regarding matters that were in court being handled by judges and that involved other parties. If you want to get into trouble as a judge, is to meet one party in the absence of the other. She wanted to do that, and that was the first cardinal misconception that she had. But the other one was she had lawyers who could voice any concerns she had with those judges that were handling those matters. So that's the first complaint. The second complaint, I've explained it, that is the first time I heard about me being approached by Judge Twala to the effect that Judge Fabricius tried to influence him by giving him a draft judgment. It was the first time when I saw it in a letter. And I consulted those judges to ask them, what about it? I started with Twala, and they were all surprised about it. So it's unfortunate she's chosen to lodge an objection, but in my view, there's no merit in both objections that she has lodged.
Thank you, President. Thank you, Justice JP.
Thank you very much, JP Tlaletse.
Thank you, JP Tlaletse. Advocate Madonsela.
Good morning, Judge President Mlambo.
Good morning, Commissioner Madonsela.
I just want to clarify one thing from your CV or your questionnaire. I see that there is reference to you having a BProc and an LLB, and then it says 1983 and 2019. I think it's page.
That is correct. Those facts are correct.
I'm not sure whether it's, I want just clarification. Do you have are these read, did you read for an LLB in 2019?
Yes. I started reading for it, I think, in 2015.
So you have a BProc degree,
Yes.
and an LLB. It's on that understanding, then it means you did an LLB when you were already a judge, and in fact, even have been a judge of the Supreme Court of Appeals.
Yes, that's true.
Why did you have to do that?
Why did I?
Why did you have to do that? You already were a judge. What was the point of it?
It was something that I regarded as outstanding. When I finished my BProc, I was under pressure to find work and help my father in terms of catering for the needs of my siblings. My mother has never worked. So the burden on my father in terms of bringing us up and paying for our fees had been so great. So when I finished my BProc, I went straight into employment. But I started studying for the LLB at that time. But the environment that being at university and outside is very different. So I had a number of mishaps in terms of failing. I decided no. But as the years went by, I decided that it's something that I could try and do. Take advantage of long leave, the long leave that we get as judges, to sit for the exams, but to try and fit in studying in between. And I think my inspiration was one justice who's now in the SCA, who was also, he had a BProc as well, so he was also studying. So I said, well, it's something outstanding I need to do, and that's why I did it.
How did it feel to read from your coursework some of the judgments which you have delivered?
It was a bit of a delicate thing, because in terms of choosing the examination centers that I sit in, I chose a center that's completely away from where I live, where people would not know me. I mean, as it happens, when we wrote the constitutional law paper, the Al-Bashir judgment was a question. And I just took my head.
Which judgment?
The Al-Bashir, or rather...
Oh, the Al-Bashir one.
The Al-Bashir judgment, yeah.
The extradition case, yeah. There is another matter connected with the background you have given us about what happened to you when you were studying and could not finish. The South African Constitution is a product of a struggle against apartheid by in particular, black people in this country and other conscientious white people in this country who sacrificed a lot in order to produce a constitution that we have today, or the liberation that South Africa has found itself in today. Did you have any participation in that struggle for the liberation of South Africa in the yesteryears?
No.
Sorry?
No.
No?
No. I mean, I regard my contribution is as a public interest and a trade union lawyer, because I was representing that sector of society, and that's practice that started pre-constitutionally.
So how can you preside and be a vanguard of a constitution you never fought for? How can you preside over and be a vanguard of a constitution that you never fought for?
I don't see that as a disqualification, Commissioner Madonsela. I mean, the Constitution is a product of blood, sweat, and tears. That is correct. I'm a beneficiary of that process, and I want to believe that I have contributed in my way to ensuring that I bring some relief to vulnerable sectors of South African society.
On a different topic, I am worried about your concept which you have presented, your concept of a visible leader who is there to see that everyone is doing what is supposed to do. It sounds to me more like an inspector general of the judges and the judiciary, or some court inspector or school inspector. judges are adults, and they're supposed to be free to do things the way they should do it. And I do not think, I'm speaking for myself, they need to be monitored as if they were school kids. The best way, I think, in which judges can be visible, or judges or leaders of the court should be visible to judges, is by lead by example in relation to, amongst other things, writing authoritative judgments which are persuasive and vindicate the law as it should be, and restate the law as it should be. Am I getting the wrong impression about your vision?
Indeed, you're getting the wrong impression. I didn't say I'll monitor the movements of judges. Visible leadership, being present, being in their space. If they require you, you should be accessible. That's what I mean by that principle. And I can tell you that a lot of judges found a lot of value that they knew that the JP is around. They would call my office, when is the JP here? And then they would walk in or ask to see me and raise whatever they want to raise with me. That's what I meant by visibility, being accessible.
Under Pillar 4, President, if I reach my 10 minutes, can I please be allowed some latitude? And also you can indicate to me if my time is up. I'm not looking at the time.
Yes, you can continue, Advocate Madlanga. Thank you.
Yes. Under Pillar 4 of your vision of pillars, pillar of visions, you speak about South African Constitution as being renowned internationally for its jurisprudence on socio-economic rights. And I attest to that because the fact that socio-economic rights have been entrenched in our Bill of Rights has become a flagship of our constitutionalism internationally. Are you able to point out to any of the decisions that you have handed down yourself which vindicate the right of individuals to socio-economic rights?
Well, a judgment that comes to mind is the Congress of South African Trade Unions and the Western Cape government that I handed down as a judge of the Labour Court. It's a matter where COSATU wanted to initiate protest action against the poor and no resourcing of schools in black townships as compared to the white areas. That was a key socio-economic right that was advanced. I can think of that judgment, yes.
Can you think of any other?
I think the judgment I wrote in the Labour Appeal Court, that is the SAPS versus Barnett, it dealt with affirmative action, the appointment of a white woman, of a black man, and sitting for the LAC, we ruled against her appointment and upheld the affirmative action policy, which was being used by SAPS not to appoint her. She appealed to the SCA. The SCA reversed us in the LAC, but the Constitutional Court reinstated our ruling. I mean, you know that affirmative action is one of the key components of the equality clause of the Constitution.
Except that equality is not a socio-economic right.
Yeah.
I was confining myself to
socio-economic rights, yeah. Okay. Well, I thought of that one. I can't think of any other judgment now, but if I think hard, I probably remember another one, yes.
Yes. I couldn't find one. I was looking for it, and I wanted to check if...
You may be correct, Commissioner Madlanga.
I may be correct or not?
You may be correct that I didn't write another one.
Yes. There is a on a different topic, you have not dealt with the complaint which was raised against you by Democracy in Action, in which they laid down an objection to your appointment or your consideration as a Chief Justice, and it relates to public protector matters. They bemoan the fact that you have demonstrated incoherence in jurisprudence that exhibit executive-mindedness in judgment writing or decision-making. They say that you find in one breath, in relation to public protector powers, that there is nothing in the Public Protector Act that forbids or prohibits the public protector to give directions to another organ of state. In that case, I think it was the NDPP. Let me go to it.
I know the cases, Commissioner.
By one breath, they say you find that there is nothing in the Public Protector Act on the Ethics Code which prohibits the public protector from instructing another organ of state to conduct further investigations. Yet in another breath, in a case involving the public protector, of course, when the government has changed, in other words, when the subject of the complaint has changed from one president to the other, or one government to the administration to the other, you find quite the opposite, where you say the Public Protector Act and the NPA are clear that the Public Protector has no powers to direct the NDPP, another organ of state, to investigate any criminal offenses. I would like you to comment on this because it is an objection raised that you do not produce coherent jurisprudence. It is as though you tailor it in accordance with the times in order to favor the establishment of the time.
Thank you very much for the question. And I'm happy you asked it because I think it provides me with an opportunity to clear it. You will recall that in the so-called state capture judgment, the remedial action that was an issue was challenged on a legality basis, right? And there was nothing found unsound with that remedial action where the public protector said the president should appoint a commission of inquiry and must consult the Chief Justice to appoint the judge to chair that commission. We found nothing wrong in that. And our basis as a bench was the authority that comes from the Nkandla judgment of the Constitutional Court that says remedial action is situational and case specific.
Which
in
case,
that matter,
which case is that?
The EFF versus President of the Republic of South
Nkandla
Africa,
judgment.
the Nkandla judgment. It laid down the law about how courts were to approach remedial action. Right? It used those two terms that I've used, like case specific, and I think I've forgotten the other phrase. So the issue on which that remedial action was premised by the public protector was that the president was implicated, and that it called for an extraordinary measure to ensure that the remedial action is seen through. And we agreed with it. So that's your first basis to saying in one breath, I say she can do that. Let's look at the second case.
Can I pause?
Yes.
Before you go to the first case, to the second case?
Yes.
I thought that you were laying down a principle of law as opposed to one of fact. when you said there is nothing in the Act that prohibits the public protector to instruct the other organ of state. It cannot be a factual matter. It is a legal issue.
It is a legal issue.
But why do you introduce the factual specifics?
But the facts of the cases are different, and I think if you allow me to discuss the two cases, I will explain what the legal stratum is.
I'm so sorry, President.
Yeah.
I'm so sorry.
I mean, there are a number of cases where the courts have upheld remedial action where the public protector does exactly that. There are. So it was accepted. And as I said, in Nkandla, the Nkandla judgment, you will recall we quoted it extensively in buttressing our finding, right? That remedial action passed the legality scrutiny. And I just want to go to the second case, because as I said in responding, there is a complaint that deals with what you're raising, and I think I responded to it. It may not be democracy, but I think it is democracy in action. I may be mistaken, but I responded to this complaint.
Sorry, Judge President, I just want to say we need to deal with it here.
Yeah.
Because the members of the public
I'm going to deal with it.
may not be aware of that complaint and how you have dealt with it in a response. So please forgive me for zooming into this issue.
Yes. The second case, the public protector found that President Ramaphosa had benefited financially from contributions to the CR17 fund. She made that finding. And on the basis of that finding, she instructed the Speaker of Parliament to subject President Ramaphosa to the Joint Committee of Parliament for disciplinary action. To start with, there was no foundation for that finding by the public protector. But worse still, a conceptual flaw was that President Ramaphosa was not a member of Parliament. Therefore, the Joint Committee had no jurisdiction over him. So that remedial action had no effect whatsoever. Let's go to the NDPP.
Well, before we go there, because
Yes.
it is a subject of a different complaint,
Yeah.
and I'll deal with it separately. I just confine myself to
It's the same case, Mandisa.
No. I'm not dealing with the appointment of the Zondo Commission.
Yes, the complaint says in the state capture judgment, we approved remedial action. And in the so-called CR17 judgment, we did not approve remedial action. So I'm dealing with that, unless I'm misunderstanding it, because those are the cases that are being referred to when people say I flip-flop. So I'm trying to respond to that, unless you're referring to another case.
Oh, no, please continue. I would come in at the right time.
Yes. You see, in the so-called CR17 case, I've dealt with the parliamentary side. The other side was, and in fact, when she instructed the Speaker, she said the Speaker must also report back to her about what she's done regarding that referral to her. And it's the same situation when it comes to her instruction to the NDPP. She said President Ramaphosa has made himself guilty of criminality. The NDP must investigate, put in place a plan to deal with this, that is the prosecution, and submit the plan to her, that is the public protector, within 30 days for her to look as to whether they've complied with the remedial action. Prosecutorial independence is deep in our Constitution. And on that basis, she went far beyond what the Public Protector Act permitted her to do and what Section 182 permitted her to do. And that's why we ruled it offside. But the issue about that remedial action, Advocate Madonsela, is that we set aside that remedial action on the basis that it had no foundation. She had no evidence to reach that conclusion and come with that remedial action. So the facts are different, and the application of the law to those facts is different. Hence, the different results. In one case, the state capture case, the remedial action was upheld. And I've mentioned that the key to that was the role allegedly played by the former president in all the malfeasance that was alleged in that report. And in the second report, there was no evidence justifying that remedial action whatsoever.
I think the undercurrent of the criticism is that you appear to be making favorable judgments in favor of President Ramaphosa and castigating the former president in all of your judgments.
Well, I think it is fair to say people are at liberty to make comments, but as I say, facts are facts in each case, and it has nothing to do with who the parties are. It's a question of applying the law to the facts that are before us. I have no soft spot for President Ramaphosa. As you say, that's the undercurrent of this thing. And I have nothing against President Zuma, former President Zuma, nothing whatsoever as a judge.
There is another case that is referred to in the Democracy in Action, that complained by Thabo Mtsweni. It's a matter that never really saw the light of the day in the Constitutional Court, in the sense that it was not considered by that court and decided finally, because the matter resolved itself. It concerns the appointment of the State Capture Commission, where you said in the judgment that the state president, or the president at the time, Mr. Jacob Zuma, could not appoint the chairperson of the Commission of Inquiry because he had a conflict of interest. And therefore, the Chief Justice must do so. That was in the circumstances where, as I recall, the law and the Act, the Commissions Act, squarely vested that power with the President and not with the Chief Justice. And there has been complaint in academic circles about whether it was competent for the court to make that finding jurisprudentially. Is there any merit? Do you think there is any merit in that criticism?
I'm aware of academic writings about that judgment, and the criticism is premised on the separation of arms principle. It's premised on that. And you correct that in terms of the Commissions Act, it's only the President who has the power to appoint the chairperson of a commission. I have explained to this commission that we did not come with that remedial action. It was put to us by the public protector. And we had to determine whether, on the legality principle, it could withstand scrutiny. And we did. We found that yes, for what the public protector justified as why she had to go that route, we found nothing wrong with the remedial action that says the President must go to the Chief Justice to appoint a judge to preside in the commission. And it's unfortunate that no appellate court has ever pronounced on that. I would have welcomed it either way.
Well, I guess by that time the blood was already on the floor because you had already said that it should be the Chief Justice who must make the call based on conflict of interest. But talking about conflict of interest just for a moment, it seems to me that, and also this has been a complaint, that cases involving the previous administration whilst in the past would be taken to the Cape Provincial Division because that's where Parliament, or even cases against Parliament, that's where Parliament is. There has been a growing tendency that those cases get litigated in your court. I mean, I'm talking about your court, sorry, it's the Gauteng High Court. And the perception now there is that it is your court under your leadership and how you allocate judges, which ensures that there is always adverse judgments against the previous judgment in your court. And that's why people prefer it. And I raise this at the level that the undercurrents of the complaint, as I said earlier, is that people see you and your court as a court that is favorable to the establishment, and they'll always find against the previous administration. What have you got to say to that?
It's unfortunate that there is this undercurrent. I'm aware of it. It's very unfortunate because factually it is also incorrect. Now, you don't mention which cases in the Western Cape Division, but I'm aware of some which went.
I can, it's just that I don't have the time.
That's fine, but I'm just saying I'm aware of some that went against the previous administration. I'm aware in the Western Cape Division. So that generalization is unfortunate and unfair. And I'm also aware of cases in Gauteng. I think I'm aware of two where I was involved, which went in favor of that administration. So the generalization is unfortunate and unfair. I can mention those cases in Gauteng.
Which I really would like you to mention them so that we clear the air in this regard.
The one of them is the Oak Bay matter. Remember the Oak Bay matter?
Is that the mining case?
The Oak Bay matter, which was launched by Minister Pravin Gordhan. We threw that case out.
About the powers of the master?
No, it's about he wanted I think he wanted an interdict or a declaratory interdict against what the Oak Bay group of companies wanted to do. And I mentioned this because I'm operating on the narrative that you are raising with me, that cases that were had in the Gauteng division against the previous administration always went against them. In that case, the dynamics were Pravin Gordhan, the Minister Pravin Gordhan, was viewed as anti the former president, right? And that matter went against Minister Pravin Gordhan.
On what aspect?
I can't remember the facts, but it's there. Advocate Mbofu raises.
Yes, and maybe we should not examine the cases. I wanted
Commissioner Madonsela, will you please bear in mind that your time allocation you have exceeded it by 5-10 minutes already. So if you could please wrap up. Thank you.
Look, I don't want to really take time for other people. I have other questions, but I think others will pick them up as we go. If they don't, I will ask for indulgence. I really don't want to take all the time.
I'm not preventing you from wrapping up your questioning, but you must be mindful of the fact that you have exceeded your time allocation already.
Thank you.
So the choice is yours.
Yes.
If you want to forego any questions that you might still have.
Yes.
Thank you.
Judge President, I think we were interrupted. Did you want to finalize this aspect? Maybe before
Yes.
I move on to the other one.
I wanted to mention the other case.
Yes, please.
You will remember that there was some drama, if I may call it that, and I'll be pardoned if that's unfortunate use of language, regarding charges being brought against Minister Pravin Gordhan. You remember that by former NDPP Sean Abrams. There was a meeting that happened at Shell House involving the NDPP and the former head of state. That matter, the legal NGOs rushed to court to try and get some relief, like forcing NDPP to resign or something like that. I can't remember the facts as we speak, but all I'm saying is, when that matter came to us, we threw it out because it had no merit. So I'm just citing those two cases to say to you, it is incorrect to generalize as you repeat this narrative that everything that was brought by the former administration went against them. They did score wins as well, but it's not my function as a judge, Commissioner Madonsela, to keep a tally of this administration has won 5, so they must start losing, or this administration has won 4, they must start losing. We don't do that. We approach cases on the facts as they come to us. And our application of the law leads us to the outcomes that we reach in those matters. So it is completely unfortunate that people are saying I was unfair and against the former state president, and I'm in favor of the current state president. I deny it. It's not like that. It's not how I operate. I value my independence and impartiality and open-mindedness.
I'm sorry if I have repeated, please don't get me wrong, I'm not repeating this complaint as if I am asserting them. I think it is fair that they should be ventilated here for you to comment on them.
Yes.
So I'm not embracing the comments as correct. I'm asking you to comment on them in order to give you a fair chance to respond to them.
Yes.
The cases that you have presided over.
Commissioner Madonsela. I think you have now taxed the patience of the members of this commission to the limit.
Yes, I don't want to go beyond that. I'm
thank
sure
you.
others will pick up this other stuff. That
Yes, let's hope so. Thank you. Commissioner
I had my hand for follow-up.
Pause.
Yes.
Commissioner Mlambo.
Thank you, Deputy President, and thank you, JP. I will be very quick. Following up on what Commissioner Madonsela said, I'm not a lawyer. He will have a better understanding than mine. But you would have been wrong if you had said the public protector has got no right to instruct other organ of the state. That would have been a wrong from a legal point of view. That would have been wrong.
Yes.
But the impression we got from the last judgment on this public protector that you had said she has no right to instruct another organ of the state. On the facts, I agree with you. You are correct. Let's say the remedial action says the joint committee must sanction the president. Correctly so you said, president is not a member of parliament and therefore that remedial action can be followed through. So it doesn't mean she can instruct parliament, but the ruling would have been this falls off, this remedial action falls off because it's not in line with what the law requires. The president is not a member of parliament and blah, blah, blah. But to say on the basis of that fact, you have no right to instruct another organ of the state, that would have been wrong because from where I'm sitting in the EFF versus the president, that was very clear by yourself, where you said she can, like she did, and therefore that remedial action must be followed through.
Yes.
Is the second judgment saying she can't give another organ of the state an instruction?
No, I think I read that judgment again. I'm sorry, should I answer?
Yes, JP.
I'm sorry about it, Michelle. I read that judgment again. I don't think we made it as a general statement of the law that she can't. We made it fact-specific that on the facts of this case, she can't do it. Because there was no substance to that remedial action in the first place. You remember, the way the judgment is structured, we dealt with the remedial action first before we dealt with these two aspects of the case of going to Parliament and going to the NDPP. And in the first part, we were clear that there was no evidence supporting this remedial action. Therefore, it was a non-starter.
Therefore, a public protector, where the facts are clear and her remedial actions can be applicable, it is well within her right to give another organ of the state an instruction based on her remedial actions, that you need to do 1, 2, 3 within a particular period.
Not to that extent as far as the prosecution is concerned.
Prosecution?
Yeah, the NPA, yes. She can't go to that extent. That one is clear. It would violate prosecutorial independence if she instructs them to say, you prosecute this way, and you report back to me. The law, that is the Public Protector Act and Section 182, allow her to say, I'm referring these matters to you because this is what I've found. You do what you want to do with them and stop there. And not say, come back to me and tell me what you've done, because she goes further than what the law allows her to do. That's the NDPP part. I need to emphasize that. Yes.
No, thank you. I don't hear her to be saying to the NDPP, you must prosecute this way and that way and all of that. I hear her to be saying, these matters are referred to you. Please follow them through within the next 30 days, report to me. And report would have been, look, we have looked into the matter, we have referred it to the Hawks for further investigation, and we'll see if we can prosecute. So that to put days for me is like she wants to make sure the matters are being followed through and within a short space of time. Not necessarily saying charge with racketeering, charge with money laundering, charge, and this must be done in the next 6 months. I hear her to be saying, I think you've got some role to play here. Please make further investigations and tell me how you've acted on these matters within a short space of time. And they can come back and say, well, we received and we have referred to these other institutions, or we have received and we are, with evidence presented to us, we have taken a decision to prosecute. I don't hear her saying, within 30 days you must have prosecuted this one. Because I know Professor Thuli Madonsela, Advocate Thuli Madonsela, did that even herself, where she will refer matters to NDPP and say, these are for further investigations.
But that's the point, isn't it?
So she's got a right to say...
To refer, look, you investigate it in terms of how you do things and leave it there and not say, come back to me and tell me what you've done. That's where...
So she can't say, come back to me in 30 days?
No, she can't.
Okay. JP, another question is about your involvement during the struggle. I have no problem with you not being involved and all of that. But there's a clip that once came through which created an impression where you were doing an interview that you went to an extent of telling some leader of the student movement or SRC or something that you should actually stop with this thing because we want to go to class. You were actually campaigning against a strike that you want to go to class and this thing must end because you are bursary and all of that. Do you remember that conversation?
No, I'm not aware of that, and I've never done that. I've never been anti-student protests. And you would know, during my time at the University of Limpopo, we had disturbances almost every year. I was never against it. I was not on record. I don't know what clip you're talking about, Commissioner Malema.
I think it was Ngalwana SC's interview with you.
Well, let me explain and put it in context. He asked me if I was involved in the struggle. I wasn't. right? I was the first one to run when the cops hit campus, right? So the question he asked was about, there's this advocate who passed away a few years ago. I think she was the husband of Sesi Baloyi, right? I didn't know him on campus, and I don't remember ever meeting him on campus, right? What I said in the interview, so I said, oh, this is, I can't remember what his name, man. Yes, yeah, Advocate Lengane. I said, oh, so this is the Mr. Lengane who was at the forefront of arranging protest action on campus. That's what I said. Not that I was against it, never.
That's fine, JP. This is not my turn. I was just making a follow-up, so my turn is going to come later. I will come with the facts on this matter. And then the last one. Did you watch any of the interviews?
No, I think I watched when yourself asked Justice Madlanga about whether South Africa was ready for a female Chief Justice. I think I watched that part.
No, I got worried because you said you never watched. When Minister Lamula asked you, said, I never watched. And then on the other side, you then said, President Maya answered this question very correctly. So I was worried, where did you see it if you have never watched? Because you said you never watched, and then later on you said President Maya answered this question correctly. So I thought there was some contradiction there.
I watched the Madlanga part, Justice Madlanga part. The President Maya part, I heard it on the news. Yes.
Thank you.
Thank you. I didn't watch President Maya's interview altogether.
Thank you, Commissioner Malema. Commissioner Dodo, is that a follow-up?
Yes, please,
Thank you.
DP. Good day, Justice Mlambo.
Good day, Commissioner Dodo.
Yes, I'm a member of Parliament. I might not be very clear legally with all the arguments, but I'm not a novice. Based on what was raised with you in respect of the objections, those who object your appointment. Now, my understanding is that the division that you had, like all other divisions, provincial divisions, are not courts of the last instance, which means that whatever rulings that you make, those can be reviewed or appealed at either the SCA or the Concord. That's my understanding. Now, based on that understanding, I want to ask you this question. And in the balance of evidence, out of all these cases that you are now a suspect that you might have been biased there and there, how many of those which were upheld by the upper divisions, in this instance the SCA or the Concord? Do you have knowledge of all those cases which were upheld? Because I want to measure whether indeed in your judgment you were either biased or not. Thank you.
To my knowledge, I have not been reversed on appeal by either the SCA or the Constitutional Court. Let me just explain the state capture judgment. I'm not sure whether it went on leave to appeal to the SCA, but by that, when that was happening, the new president had distanced himself from the litigation. So I'm not aware what happened to that one, but all the others, especially this one about the instructions to Parliament and to the NDPP, those were upheld by the Constitutional Court.
That's my point. Specifically those of the public protector?
Yes.
As well as the so-called CR17. Were they upheld by those divisions?
They were upheld by the Constitutional Court.
All right, thank you very much. Thank you, Advocate Justice Petzer.
Thank you, Commissioner Dodovu. Advocate Advocate Kane.
Thank you, Acting President. Good morning, Judge Mlambo.
Good afternoon, Advocate Kane.
Time has gone quickly. When you were delivering your vision statement at the outset, what struck me so powerfully was the feeling that this is very much the man I know. And you have consistently engaged with the leaders of the bar within your jurisdiction. I'm quite sure that you've done it with every leader of the bar, not only me. And I thought it would be a good thing then to bring out two things from that engagement and the advocates' profession's perspective. The one is an aspect they raise in their report containing the submissions of the GCB, and it pertains to your service as leader of the busiest division in this country, and actually the implication that you could have had a choice to have adopted another career path, going to the Supreme Court of Appeal, but you actually have engaged that hard work by choice. Is that correct, and why did you make such a decision?
Thanks for the question, Advocate Kane. When I was in the SCA, I was approached by Deputy Judge President Wegley, who was the DJP of the Labour Court at the time. And he had asked to see me when I was on leave or on recess from the SCA. And when I saw him, he said he would request me to stand to be JP of the Labour Court. I was taken aback because I said, but you are the DJP. You should take over when, you should apply, not take over, you should apply when Acting Chief Justice Zondo's term ends. He said, no, I want to be led by you. I said, but you've seen no leadership qualities from me. He says, no, that's incorrect. And he referred to my Labour Court experience. Not Labour Court, sorry, my legal aid SA experience, because I was at the helm of that institution. So I initially rejected him, but he persisted until I engaged with the issue. And I thought about it, and I said, well, if I'm not going to lose anything by way of a drop in salary or benefits, if I make a sideways move, then I'll go for it. And then I applied to become JP of the Labour Court. And what had moved me was that he specifically said there could be a career for you in court leadership based on what you've done at Legal Aid South Africa. And that's what made me think about this thing. And the rest is history, if I may say so.
You have emphasized in your vision statement that how much priority you place on engagement with all the role players to make the administration of justice more efficient. And in that, you've even mentioned communication strategies and the importance of the independence and the impartiality of the judiciary. Now, in that regard, there was an incident during the time where Commissioner Mpofu and I were leading the Bar Council, which you no doubt have forgotten because it would have been insignificant in all the matters you deal with. But it is a nice illustration, and I thought I should remind you of it and ask you a few questions following from that, because it so emphasizes the very things you've brought out in your vision statement. What had happened was that the press had reported, and this was during September 2016, that you had actually confirmed the existence of corruption in the judiciary and that some judges were taking favors or kickbacks, and that practice needed to stop. It was reported as something of which you had knowledge, and we engaged on it at the time in correspondence. And I'll remind you that what you had done is you had immediately engaged the heads of court and they had given you their support to ask the Office of the Chief Justice Communications to write to that media house demanding a retraction of the article. And the Office of the Chief Justice then did that on your behalf, setting out the facts, and the media house in fact did offer you an apology and retract the article entirely. Now, it pertained to the independence and the impartiality of the judiciary. What would have happened had you been able to identify any judge of which you had known that perhaps had been engaged in such conduct?
Oh, had I discovered that a judge was corrupt, was actually taking money, I would have taken the issue to the Chief Justice and to be guided by him whether I should lay a complaint against the judge or not. But I would not have kept quiet about the matter had that been the case. And as you correctly say, that's not what I had said in the statement that was attributed to me.
You will be chairing the small JSC if you're appointed as the new Chief Justice. And what would your approach be in relation to any threat to the independence or impartiality of the judiciary?
You link that to chairing the small JSC. I don't understand why you do that, but...
let me explain. Yeah. It's because any matter or complaint of that sort of serious nature against a judge would fall under the jurisdiction of the small JSC, yes, insofar as remedial steps or disciplinary action is concerned.
Yes. Let me answer the question this way. I, as JP, have been approached and have written judgments about the impact of Section 47. That is the immunity of judges against being sued. Now, I refer to that example deliberately because when I have facts before me, I approach the matter with a completely open mind. But if I had had a previous engagement, say it's a matter that I've reported to the JSC to say, this judge is on the take. If that matter comes before the small JSC, clearly I cannot participate in the proceedings of the small JSC. It has to be the Deputy Chief Justice because he's got no involvement in that matter. But where I have had no involvement whatsoever with the occurrences that are on the agenda of the small JSC, I don't see any problem in continuing to chair the small JSC, even if it involves judges, because it is envisaged that the JCC is a body created to look at conduct by judges by its nature.
You mentioned that part of the problem with judicial complaints and them taking too long is that we are seen to be hard on litigants but kind on ourselves. Now, that relates to this question because so many, or virtually every judge that's going to be facing some sort of process before the small JSC would be a colleague of yours, somebody who you've worked with.
Yes.
And in that regard, I'd like to hear your view as to making those tough decisions when it comes to disciplining people that you may well be very fond of.
Yes. I stand by the statement I've made that if, as the judiciary, we are seen to be hard on litigants, the treatment has to be the same when it even comes to judges who are accused of or in judicial complaints. But I'm not making a judgment that they are guilty. So that does not compromise my participation in chairing the small JSC. What I was talking about was, I think the situation can improve in terms of the handling and processing of JCC complaints. And that's why I made the example that most of the judges who sit there have got their own workloads in their own divisions. and they have no special dispensation of time to attend to JCC work. They attend to that work after hours and on weekends. And that's why I think there's a role for retired judges, right, who have no active roles to come and assist in that space. So I'm just clarifying that I wasn't passing judgment that any judge who's facing a judicial complaint is guilty. I wasn't passing that judgment, no.
No, I didn't understand you to be. I was just testing your willingness to take on that very difficult,
Yes.
onerous function that may well come to you.
Yes.
Thank you.
Yes, I could definitely do that. I don't have a problem. I mean, if I've not been involved in the matter, I know of a number of complaints that I have personally lodged to the JSC. Should I be appointed and those matters come to the JSC, clearly, I can't participate.
Yes.
Yes.
Thank you, Acting President.
Thank you, Advocate Kane.
Follow up, Acting President.
Yes, you may proceed, Honorable Minister.
No, thank you. On this issue of the small JSC, Judge President, my worry, and you will correct me and you will raise your view, is that I hear every time a candidate comes here, you say, hey, we have known each other for 20 years or 50 years. I've heard you with Justice Petse here, and I suspect that goes with many of your colleagues. And now you will be chairing this thing that must say they must be impeached or you must take their salary or whatever that is the outcome. How do you handle it in ensuring that indeed justice is done through that process when it's your long-held colleague that you know each other for many years and practice or as judges or whatever?
Well, my sense of it, Minister, is we have to know each other. We know each other. We are colleagues. But the fact that we know each other can never be an impediment in us doing what the JCC work demands or calls upon us. It's a different story if you've had some involvement or you've expressed yourself in favor of one or other of the competing issues at stake in that particular complaint. Then you've got to step out. But based on knowing a colleague only, I don't think that should disqualify me, if I'm appointed as Chief Justice, to preside in those matters. I don't think so. But that's me. People may differ with me, but just know, I know JP Tlaletse. We know each other. I used to brief his firm as a correspondent when we were all in practice. But should JP Tlaletse be charged with some misconduct and he comes before me, we sit together as heads of courts, perhaps maybe that could be a dynamic that could come in. But generally, that I've known him for so many years shouldn't disqualify me from participating in those proceedings. Because I am one judge who say, if I have an open mind about things, I have an open mind about things. And that's why I would be prepared to participate in those proceedings.
Follow up, President.
Are you done, Honorable Minister? Thank you.
I did say, President, that I would want to leave other questions and follow up if other commissioners picked up the issue. And this is one of the issues that I wanted to deal with, and I would like to follow up on the minister's question.
Keep it short, Commissioner Madonza.
Thank you, President. Judge President, as you know, my other role in this commission, JSC, is to be in charge of litigation against the commission, and I've interacted with you in that regard.
Yes.
It is a matter of public record that Judge President Mlambo has taken the JSC to court. Incidentally, the matter is in your court, in High Court. The matter is on my calculation, one way or the other, likely to end up in the Constitutional Court. If that were to happen, given the fact that Judge President Mlambo, in the papers in court, accuses you of conflict of interest, in the sense that you said in his judgment, in circumstances where you have dealt with other cases, will that not place you in a precarious position when you are the Chief Justice and the matter serves before the Constitutional Court in which you preside, firstly? Secondly, is it at all desirable, and will it not put much pressure on the colleagues in the Constitutional Court, hearing a matter in which the Chief Justice, the sitting Chief Justice, is a party against whom certain allegations of misconduct, because that's what effectively Judge Mlambo is saying about you, are concerned and decide that issue?
Well, Commissioner Madonsela, Judge Mlambo has pointedly raised the issue. Subsequently, you would know that I told the small JSC that I did not regard myself as conflicted. I still do. Not conflicted, I have no gripe or grudge or any issue against Judge President Mlambo whatsoever. And I said as much when the small JSC met. But the development of matter is that now the matter has proceeded to the point where Judge President Mlambo has pointedly raised the issue, right, that I should not have said there. Whichever way the matter goes in the High Court, if it comes to the Constitutional Court, I can never participate in that matter. I think that's a given, because I'm mentioned as having taken one or other side. It would be completely improper for me to sit in that matter. It's a function of life, our judicial careers, Commissioner Madonsela, that we do a lot of things. And when we do things, we don't take one step and say, I'm not taking this step because there's a likely issue that 20 years down the line, this thing will be raised and whatever. You do the work as it comes to you at the time. Because if that would be the approach, then I doubt if we'll be able to do much, because we would be scared. We'll always be cautious, right? So my short answer to your question is, now that Judge President Mlambo has raised the issue the way he has, I cannot participate in any follow-up proceedings that take place should I be appointed as Chief Justice.
The second part of the question is, what will that not bring much pressure on your colleagues who will be sitting, you'll be the Chief Justice for a considerable period of time, they have made a decision against you? Is that not going to create much tension and pressure on them to find against a Chief Justice who is already a Chief Justice in the term that, in a long time, that you are poised to stay in the Constitutional Court if we were to be appointed? And not so much about you, but so much about them.
Yeah. Well, I am not sure I agree with you, because I can cite examples where Chief Justices, I remember the matter involving the extension of Chief Justice Mlambo's term. The Constitutional Court sat in that matter, didn't they?
But then he left immediately.
Yeah, but he was leaving, but I'm saying the pressure you say they will have, they would have had pressure to sit and decide on that matter, isn't it? But they didn't have that pressure. They didn't. So I don't agree with you that we should willy-nilly look at this issue the way you are putting it. The Deputy Judge President Mujapilo case is an example. He made findings against a sitting Chief Justice. If what you put to me is correct, he would have been under pressure not to do so. So I don't agree with you that justices of the Constitutional Court will feel pressured if they were to sit in a matter where I'm implicated in one way or the other.
Acting
Acting
Judge,
President.
on this point,
A brief follow-up.
brief, very brief.
And it must be brief,
Yeah, it's very
Honorable
brief.
Minister.
It's very brief. I heard Council Madonsela saying this matter now of Judge Hlophe is before the Gauteng High Court,
Yes.
if I'm correct. So what he's saying, if you are a Chief Justice, will it not be applicable now, as we speak, because you are a Judge President of the Gauteng High Court? It means that pressure will be there.
Correct, Minister. It's an issue I didn't think of, but yes. If Commissioner Madonsela is correct, yes, then those judges should feel pressured because it's the leader of their division who is alleged to have been misconducted himself in one way or the other. It's the same principle, I would imagine.
Commissioner Advocate Mpofu.
Thank you, Chair, but I thought Commissioner Singh wanted to do a follow-up, unless if you are overruling him.
I don't think he noticed me on this end. Probably our voices are similar. I just wanted a brief follow-up on this one.
Please, you may proceed, Commissioner Singh.
Thank you very much, and good afternoon, Judge President
Good
Mlambo.
afternoon, Commissioner Singh.
As you are well aware, we on this side of the House do not sit on the small JSC.
Yes.
So we're not privy to everything that happens, in the small JSC and the agenda, etc. But you've said to this commission that there are a number of cases that you've reported to the JCC. Can you give us an idea, without going into detail, how many cases and what time has lapsed in the investigation of those cases? It would be interesting to know how many judges have been reported for misconduct.
Well, actually, I should have, it's two, actually. It's two cases against two judges for reserving judgments for very long periods. It's those two. One is a matter where the evidence leaders seek they sought an affidavit from me. It involved a judge whose matter is before the JCC, I think. But I didn't lodge that complaint in that one.
Okay, and to your knowledge, these matters have not been finalized yet by the JCC. And how long ago were they reported?
No, well, I think the JCC met a few weeks ago. Regarding the two, I don't know what the result was. Regarding those two, whether they've been referred to a tribunal stage or not. But they're still pending, yes.
Well, thank you.
Thank you, Commissioner Singh. Advocate Mpofu.
Thank you very much, Acting President. Good afternoon, JP.
Good afternoon, Mhlekazi.
Thank you. Mhlekazi ungafanelanga ukupupa. Thank you, JP. Yes, I think I must also start with declarations. Along the lines the Minister said, we all know each other. It is, as Justice Maya said, it's a small community. Just to declare that you and I did articles together, and you accused me of throwing mud with my fancy car when I was driving past you. But I also want to plead guilty on two counts which you have always accused me of. One, this morning about bombarding you with complex cases and special allocations. The second one is not heeding to your constant invitations to come and act as a judge, which you also have made sure that I remember all the time. But I want to talk to you about the two areas, maybe three, depending on how much time I will be given. I'll also ask for a little bit of leeway. You know that I sit here representing primarily advocates for transformation, so through the auspices of the GCB. But so I have to talk about that, otherwise I'll lose my job. And but I want to talk also generally, specifically about the three areas. If you agree with me, I mapped out three broad areas that we are dealing with in this particular type of interview. And the one was judicial skills and experience. You've spoken a lot about that. The second one is leadership and people skills. And the third broad area, administrative and management skills. Would you agree that, broadly speaking, there might be other things? Those are the types of attributes that one is looking for in a Chief Justice.
I would agree with you, Commissioner Boff.
Thanks. Now, I don't want to waste your time. Let me just put it up front that being a person who's in this division and who has interacted with you on many fronts, I have no doubt that you are definitely probably one of the most accessible leaders of any court. I'm prepared to say that even without having met all of them. And have the patience to deal with a busy division, as has been mentioned, but have time for all of us, whether we're junior or senior or from all walks of life. And so as far as leadership and people skills are concerned, I'm prepared to say that you are almost 90 to 100%. Then comes also the area of administrative and management skills. You've said everything but legal aid, court management, case lines is a star performance. And again, I think without fear of contradiction, I can say that your skills in those areas are, I'll go as far as to say, unmatched. It seems that the area where there are questions, if you follow up, and I want to confirm what Advocate Kane said about our interactions when we were in the leadership of the profession. The area that seems to be needing your assurance of this commission seems to be in the first area of the three that you and I have agreed, which is the judicial skills, the judicial experience, the issues about constitutional cases that you've done, and so on and so on. And I'm giving you an opportunity to deal with that, particularly because, as you know, as Commissioner Barnett said, we have 4 good candidates. And the other candidates have got almost an unquestioned pedigree in that first area. So where you beat them hands down in the other 2 areas, in my book at least, in that one area, there might be questions. So I'd like you to brag a little bit, don't be modest. Somebody said you're being modest. And deal with, if when we're deliberating, somebody says, well, JP Mlambo is good, as a good administrator, a good leader, and so on, but he's not an intellectual leader on the bench. What would you say?
I would dispute that. As I said when I finished my vision, that in as much as I'm an administrator, I'm also a judge, as well as a head of court. So I've presided in matters, some of them very complicated, which really challenged our thinking and how we were going to approach them. And I've presided in quite a number of full court matters that are varied, you know. So I would, on that basis, dispute that, because you would criticize me of being weak on jurisprudence if I've not sat and presided and written judgments. I have done that. So I would dispute the statement you are putting to me.
Okay, well, all right. No, what I was really getting into is you must give me the arms to dispute that statement if it is made. Yeah. I can't just say I'm disputing the statement if it's made in the deliberations.
Yes. I mean, from my days in the Labour Court, I mentioned one judgment in the Western Cape Department. I dealt with that matter, which looks at socio-economic rights, as I think Advocate Madonsela asked me the question. I also sat in the Barnard case. You would know that that case called on an interpretation of how courts view affirmative action policies by governments. I've sat in that matter. I've sat in the SCA in a number of matters. I can remember the Fraser Absa Bank matter, which dealt with whether he was entitled to access the frozen funds to fund his legal defense, because that goes to the heart of the fair trial rights issues in the Constitution. I've sat in the Haag-Doorn Belt matter. You remember Haag-Doorn Belt was a very big land matter in the Northwest. I didn't scribe it, but I was part of that bench in that matter. I sat in, I think, the Buckhazen versus Napier matter, which dealt with
before it went up.
Time clauses. I was in the SCA, and I think the CC upheld our direction in that matter. In this division, I've sat in a number of other matters. The Al-Bashir matter, called on the application of international law in a bit, the Rome Statute as signed by South Africa. I sat in that matter.
Yeah. Okay. That's, I hear that. And that's why I was thinking you were shortchanging yourself even when you're answering Advocate Matt Donsel. Because last year you sat, and again, you might not have ascribed the judgment, but you sat in a case that I was involved in, which involved socio-economic rights, which was education. The case around the
One South Africa case.
One South Africa case,
Yes.
yeah. So, okay. And incidentally, who wrote the judgment in that case?
It was assigned to all of us. What I do in these full courts, that's why the judgment comes out as a court judgment. Even in the fair trade tobacco case, it comes out as a judgment of the court because we allocate each other sections to write on. That's why it comes out as a court judgment.
All right. Okay. Now, okay, thanks. That satisfies me in that area. Then the second area is kind of a broad area. All sorts of things have been said here. I'll call it whispering campaigns, or you called it undercurrents, about all sorts of things ranging from corruption, kickbacks, that your court is captured by a particular faction, and so on. You are aware of those, you've said. You are aware. You dispute them, of course, but you are aware of them.
Yes, those that we dealt with Commissioner Madonsela, yes.
Yeah. And Commissioner Kane.
Yes.
Now, I want to deal with two specific areas where I want you to allay any fears about any of those whispering campaigns. Firstly, you'll say if you're aware, and also then deal with it. The first one deals with allocation. You know that, of course, that one of the ways in which the power of a JP can be abused is the power of allocation. Possibly, So this is one of the areas. There is a tendency. I don't know if this is deliberate, but all your three-judge panels, almost it looks like it's compulsory that they must have white judges. And in particular, then there would be specific persons who are always allocated into these. And just JP Kaleti said, you sit in these matters and you sit with other senior colleagues. But the evidence is that some of these people are not even senior colleagues. There's one person in particular, I think you might know who I'm speaking about, who has sat on my count 1, 2, 3, 4 of the full benches with you, and she's not even maybe 4 or 5 years on the bench. Is there any specific reasons why other judges, black or white, don't get these fancy allocations and they seem to go to junior judges?
Well, you've generalized it too much, Commissioner Mpofu, but let me just explain how I do the roster in Gauteng. I do and finalize the roster for the next term. Like I'm acting in the CC now. This term, the High Court term will end the end of March, but it starts again, I think, towards the end of April, if I'm not mistaken. But I would make sure that I finalize the roster before the term ends, so that when judges go into recess, they know what they are allocated to, right? So I have a template in terms of which I allocate, I do the roster, to make sure that there's equal distribution of allocations throughout the term. Now, I would be interested to know who is this one person who've sat 5 times with me, because I don't recall sitting in such many cases with one particular judge, except those cases in the disaster management situation. I would have sat with one panel in probably three cases, simply to avoid the issue of split decisions coming from one division. So I would be interested to know who that judge is and who you say is junior. But let me just finish explaining this.
Yes.
So when I do the roster, it just follows. I would know that if this judge started the term in the opposed motion role, the first term, and I want to make sure that in the second term he doesn't start in the opposed motion role. He starts in a different work area, right? So that especially their rotation in the difficult courts like the opposed motion, special motions, and urgent courts, all of them have their times in those matters. So it's not that I go out of my way to handpick and select certain judges to hear particular matters. That's not the roster I do. I can show you and I can share with you how the template roster is done.
Yeah, okay. All right. So, okay. So you'll say, therefore then, you'll say it's a coincidence that at least I would think of 4 full bench panels, some of which I was involved in, one in which you were not involved in. But I'll tell you, in Freedom Front Plus versus President of RSA, this was the bench, Mlambo, Kitley, Kolapen.
Yes.
In One South African Movement, President of RSA, Mlambo, Kitley, Kolapen.
Yes.
President of RSA versus Public Protector, that's the Busasa CR17 case.
Yes.
Mlambo, Matojane, Kitley.
Yes.
In another relatively high-profile matter, Moyo versus Old Mutual, which I was involved in, that one, but where you put in a panel, Meya, Kitley, Matojane. So you're saying that's just coincidence?
No, it's coincidental. I don't go out of my way to handpick judges. I mean, where the duty roster places acting judges in the urgent court, that's where I intervene because I don't want mishaps to happen. I then swap them with permanent judges because the urgent court, as you know, is a very difficult court.
Yes, but you'd agree at least that when you are in charge of the largest division with a large number of judges of different seniorities, a judge such as Judge Kitley is one of the more junior. I think she's about 5 years or so.
Well, I can mention other judges who are junior to her who've sat in actually serious matters.
No, my
the
question...
issue of, no, I want to answer that question because you want to emphasize the fact that she's junior. It's a coincidence she sat in all those matters, but the fact of the matter is if you want proper transfer of skills and exposure, you can't ignore junior judges sitting in the difficult cases. You can't.
Transfer of skills from what to what? Because she's a junior judge. What
Yes.
skills?
No, exposure to how they deal with difficult cases.
Okay. Then there's, so you then refute any suggestion that there's a judicial hit squad in your division?
No, there's no
Specific
hit squad.
group of people. Okay. No, those are the kinds of terms that have been used here. Okay. So, okay, that's fine. Then the last one is something again that I know you're aware of, but unfortunately it's probably again one of these what I call whispering campaigns. But I'd like you to deal with it particularly because it's much more serious. There have been allegations of sexual harassment in which you are implicated, rightly or wrongly. And it's one of those things which is so frustrating, I think probably more for you, because I even thought now someone will put in a complaint and nobody did. But you and I have spoken about this maybe informally. Where does this come from? Is there any substance to it? Are there any victims somewhere out there who might come out when you are Chief Justice, which would embarrass the country? Or is this just one of those, and I'm an expert in this, where people just smear without any foundation? And I'd like to put it out there because, as you know, this is a serious matter. It would be an impeachable matter if it had any substance.
There is no substance to that rumor. It's a rumor, and I think it's an insidious, poisonous rumor. There's actually no substance to it. When I heard about it, I was actually shocked, right? And I was actually hoping that someone would come up and say, I'm one of those who's been sexually harassed by Judge President Mlambo. So it's unfortunate that people are using people's names willy-nilly in spreading rumors of this nature. There's completely no substance to that rumor.
Thank you. And so there'll be no, if you are appointed, there'll be no surprises in that regard that might embarrass the country?
No, never.
Thank you very much.
Follow-up, Chair.
Thank you, Commissioner Mpofu. Commissioner Malema.
No, on the rumor of sexual harassment, JP, what got me more worried was that it is actually happening to women who want to be acting judges. So for them to get access to act, they get to be subjected to all those manner of things.
Well, Commissioner Malema, you seem to have details. I don't have those details. I know that as I sit here, I have never sexually harassed anyone, especially people who have aspirations of coming to the bench. I have not sexually harassed anyone. And let me put it to you this way. I've shared with this commission the statistics of how many women judges I have been instrumental in ensuring they either come to act or they come and appointed permanently in the division. If I understand what you're putting to me, you're suggesting that I have, in a way, I think you put it as sexual harassment, sexually harassed women judges who want to be acting judges. I don't know if I understood you well, because I think that's what you said.
No, that there should be some sexual favors. It will amount to sexual harassment for women to qualify to act in the Gauteng division.
Yeah, no, there's no substance to that. And I bring it back to you to say, if you look at the number, I've not shared with the commission the number of acting women judges I've appointed, because it's many of them. If you look at that number and you look at the number of women judges who've actually been appointed, the suggestion is that I would have demanded sexual favors from them for them to get the nod. I think it's an insult to me and to those women judges to spread a rumor of this nature. There is completely no substance whatsoever to that rumor.
Now, the last point, JP, I think it was raised by Commissioner Mpofu, but to an extent by Commissioner Madonsela. The issue of acquiring the LLB when you are already sitting a judge, but also it goes to an extent of then getting this permanently, which will deal with, maybe put differently. Maybe it can come in two approaches. One, that the LLB was acquired because you have a desire to improve your writing skills, because you are challenged in writing judgment. And as a result, you bring white judges on the full bench to help you write judgments, because when it comes to writing of judgment, there is a limitation. And this particular judge that get to be mentioned, I think she's the most preferred judge, because she fills in that gap where there is a limitation when it comes to judgment writing.
Well, I don't understand how you link the LLB and writing judgments, because those two don't connect.
No, when you are sitting on the bench already,
Yes.
you came to appreciate the limitation that you needed to improve your qualifications and skills, and part of which will be to engage in that particular program of acquiring the LLB. And then when they stretch it further, is that no, that did not help. That's why there's permanently a white person on the panel, and where you are, then there will be this other judge who helps as well with regard to writing. That's why I was interested in that question as to who wrote the judgment. Because I thought in your answering, then it was going to confirm that she's actually the one who writes the most of those judgments.
I've answered that question, that we allocate each other sections in the judgment, which one writes on which aspect. That's why they come out as full court judgments. But I think there's something factually out of place in that allegation, that I realized that I had a shortcoming in writing judgments. I started studying for the LLB in 2015. I'd been a judge for many years. I'd been writing judgments all those years. And no one has ever said JP Mlambo has been writing suspect judgments in all those years. So it can never be correct, Commissioner Malema, that I decided to do the LLB because I wanted to improve my writing skills. It can never be correct. I'd been a judge for a very long time before I decided to finish my unfinished work of studying for the LLB. I hope you understand, you see my point. I've been writing judgments. Even in the SCA, I've been writing judgments. And in the LAC, I've been writing judgments.
No, I'm actually inspired by you going to write an LLB while a sitting judge.
Yes.
I'm just bringing these matters to you so that you can clarify them. But sitting judge writing an LLB should serve as an inspiration to many of us. So I make no issue with that. I'm just saying, following up on what they were saying.
Yes.
And these are issues related to those allegations.
Yes.
But perhaps it is for transformative purposes or whatever reason, I don't know. In your approach, because of constituting a full bench, do you always see a need to put a white person there?
Not
because the story is that you're putting white people because you want them to write.
No. It's an unfortunate statement to make that I put in white, because it suggests that I think white judges are the only ones who are good and better at writing judgments. It's incorrect. It's incorrect.
Thank you, JP.
Thank you.
Follow up.
Thank you, Commissioner Malema. Honorable Minister.
JP, my follow-up relates to this matter of the manner of appointment of acting judges. I think on the sexual harassment one you have responded to. But my question is that is a discussion we had yourselves as heads of courts and ourselves on some issues that were raised by the profession for guidelines for acting appointments. and I know that you know that there's what has delayed us is the processes in the Limpopo High Court as we speak now. But don't you think if there is a kind of a transparent process of the appointment of acting judges, we will be able to minimize most of these complaints and issues that comes and rumors that comes in the public or from the profession? We also dealt with this matter when we were interviewing Judge President Maya. I think it was BLA, they raised an issue in a manner of acting appointments.
Let me speak for what I do in the Gauteng division. And there are advocates who practice in this division, in this commission today. They know that when I approach them to suggest people to act in the division, I tell them that the person must have been in practice for not less than 12 years. And I emphasize that I want them to focus more on women candidates, because my problem is I don't see many junior briefs by women candidates, or I don't see even women silks running complex matters on their own without being led by male silks. So if I were to follow those stereotypes, I would exclude junior people altogether. And I want to avoid excluding junior people, because at the bar, if you are 12 years, you've done enough to raise your hand and say, I can act as a judge. So I want to believe in Gauteng, I'm transparent. They know on what basis I select acting judges. And almost invariably, whatever recommendations that come my way for acting judges, the advocates know. I would say, don't recommend someone because he or she is your friend. Recommend them on the basis of what they've done at the bar, what work they've done, what cases they've argued, where they've appeared, but 12 years and above. And the emphasis is always on women, because I'm on gender transformation.
You may well be right, Judge President, on that. My contention on the matter is that the practice where the JPs obviously recommend or appoint and so forth. I know I appoint, but that recommendation, it's a practice that comes from the old system where there were few white practitioners. And the JPs will really know the number of people, which specialty. So it was a bit easy also to quickly consult with some few leadership of the profession. But now the practitioners are many with diverse backgrounds. There could be a brilliant practitioner somewhere in Springs or in the outskirts of South Africa that the JP may not know, or some of the leadership of the profession may not know. But it's a brilliant guy or lady somewhere. So if there is some guideline or processes that anyone who may want to, or anyone may want to nominate, will that not really help to enhance this system of transparency?
That's what applies in Gauteng, Minister. You can ask the advocates who sit here. I ask them. I always ask them, like Advocate Mpofu. I've said, okay, I've chased you. I hope one day you'll come to act, but who can you recommend? I'm always receiving recommendations from the bar and from the private sector, the private attorney sector, of people who are recommended to come and act. So I try my best. It's true. I mean, when I approached Justice Mbuyiseli, I didn't know her. I was JP of the Labour Court. But when she was recommended, I said, well, this is someone who must come and act here. And Minister, some of the things that are not known is that when it became known, I'm that type of consultative JP, when it became known in the court that I was intending to appoint Justice Mbuyiseli to come and act in the Labour Court, there was a delegation of senior judges who came to see me to say, don't do it. She's too junior, she knows nothing about labor. I said, well, I'm bringing her, it's my call, I'm bringing her because I think she'll add value. Look at where she is today. So I'm saying I'm always inviting those recommendations for people to come and act. And, you know, this problem of juniorizing people and of trying to keep people out of certain work areas or to keep people out of acting appointments is something we face as JPs. There's always grandstanding on one court or another, but I'm the type of JP to say, if you have an issue with this person that I want to appoint to act, tell me why. I want documented evidence why you are against it. And those objections fizzle into nothing, right? Because it's like that. It's in the nature of the legal profession to backstab, you know. But I challenge it, and I make sure that, no, I discovered a very brilliant tax law practitioner by way of recommendation. And she became appointed by this JSC, and she's a woman. I was surprised to start with that there's a woman who specializes in tax law. I didn't know her. She came, and she was such a revelation because she assisted in revamping the tax court and ensuring that its processes are streamlined. She knows tax law like nobody's business. So I'm saying, I agree with you. We need to be open as heads of courts to listen, to receive, and to evaluate whatever recommendations we get and to factor them in. And I do that, you know.
No, thank you.
Can I follow up?
Thank you, Honorable Minister.
Can I follow up, Acting President?
Yes, I'll give you an opportunity after Commissioner Mapisa Magula.
Okay.
Commissioner.
Thank you very much, Acting President. Good afternoon.
Good afternoon, Madam
President
Speaker.
Mlambo.
It feels different. I'm sitting far away today from you.
Judge President, there's a matter which was raised here by Commissioner Mbofu.
Yes.
And I've just been trying to think how I should raise a follow-up question with you on this matter. Because you mentioned that you became aware of the rumor. And what has also come out is that, you know, it's like by faceless people. I would like to know when first did you become aware of the rumor? And whether there's ever been a discussion between yourself and the CJ on the matter. Yeah, it is a sensitive matter. I've not heard you saying, you know, you became aware and an allegation was made by a particular person. I'm fully aware of that. But my question would be, when did you become aware of the rumor? Thank you.
Thanks for the question, Madam Speaker. There are many allegations that are always in circulation. I mean, Commissioner Mbofu said it. They are always there, allegation, whatever. And because it's in the nature of the legal profession to gossip. If you want a profession that gossips, go to the legal profession. They gossip big time on nonsense. And when this Chief Justice nomination process started, I got a call from a retired judge in the Western Cape who said, hey, I've heard something disturbing about you. And I said, what? And I was told what, and it was what Commissioner Mbofu raised. I was shocked. I said, but why are people saying these things to me? Do you have a name? He says, no, I don't have a name. It's just being spoken about, but hush, hush, you know. So it started now in the currency of this CJ process starting. So I had a discussion with no one because I just ascribed it to the rumor mill that always happens in the judiciary. I mean, even before I took over, I've heard rumors about other JPs, but I didn't think it's worthy of me to act on it because, as you say, Madam Speaker, it's a rumor that's difficult to pin. Who? Why? Where? Why are they not coming out? And the rumors don't identify anyone in any way, you know. So I feel pained that this rumor has now found its way into my interview, because I just feel it gives credence to the poisoning of the candidature that I have in this position. And it started and gained steam in this process. Clearly, its purpose is to poison my candidature. So I didn't speak to anyone. I didn't think it's worthy of me to action it with anyone.
Thank you very much, Judge President Mlambo. Thank you. Thank you.
Thank you, Commissioner Mapisa Ngagula. Commissioner Magwanisha.
Just two quick follow-ups, Chair. Thank you very much. Good morning, Judge President.
Good afternoon, Commissioner Magwanisha.
No,
that means I'm in for a long slog if you're still in the morning.
No, my apologies. I think it's me who's sleeping. Now, you said that you have a sexual harassment policy.
Yes.
Has that policy ever been used? Ever?
No.
Not at all?
In fact, let me explain. It was not used, but the reason we crafted it, there were complaints that were lodged with me by two female colleagues in Pretoria who felt that they were the victims of offensive conduct by their male colleagues. And I asked them, I said, this is serious. I think it should go further than this. They said, no, JP, I'm raising it with you as head of the court. I don't want to take it forward. I just want you to be aware, right? So I consulted the DJP. DJP Ludwaba said, hey, something serious was reported to me, right? And the good thing, if I recall, in one of those instances, the male colleague was identified as to who did it, you see? So I consulted the DJP. I said, the judges said to me explicitly, under no circumstances do you take this thing forward, wherever. We're raising it with you, see what you do with it divisionally. So I then consulted the two colleagues to say, look, I've spoken to the DJP. We think these are serious things, and we want to impress on you to consider lodging complaints with the JSC, right? And they refused. So we said, well, as a fallback position, shouldn't we engage an experienced retired judge to come and have a chat with you? Because all they said, they wanted this thing to be spoken over and resolved so that it's brought to the understanding of those colleagues that this is wrong. So we tabled it in a judges' meeting. And we spoke about it extensively, that colleagues, as JP, the leadership of the division, we've received this. Please desist from doing this. And as a follow-up, we got a retired justice of the Constitutional Court just to come and have a session, a debriefing session with those ladies, because I felt that they were hurt, but they didn't want to take the matter forward, right? But the upshot of it all, in both judges' meetings, Joburg and Pretoria, the view was, let's come with a sexual harassment policy that will enable those who are victims of this conduct to be assured that they will not be victimized should they come up. And we did that. It was drafted and was circulated amongst all judges, and it was adopted.
The last one. I can see that Commissioner Mpofu is giving you sleepless nights. You have been running after him to act. Now, have you considered approaching legal academics to act?
I do. I've always said, Commissioner Magwanishe, that one of the acting slots in the division is for legal academics. I mean, this commission appointed Judge van der Schyff about 3 years ago. She was an academic, right? But there's an academic who's acting now, Professor Poko. He's acting. And I didn't know him from any bar of soap, but the man is good, you know. So there are particular problems that apply to the academic world. The time that they must get to come and act is always a difficulty between them and their deans. But whatever the space is, because some of them, like Professor van der Schyff, some of the times she came to act, she had to do so without pay, right, from her institution, right? Well, she was going to be paid an acting judge salary in any way. So I'm saying there are particular difficulties. I remember having a number of engagements at VETS where I raised this particular issue to say, why is it always a problem when we try to invite academics to come and act and they tell us that the management structure is blocking their way? It didn't come to much, although I think a year or two thereafter, one of the academics from VETS came to act, a family law practitioner. But there is a slot. Commissioner Schlemmer knows. I've always mentioned it in this JSC.
Thank you, JP. Thank you, Acting.
AJP.
Thank you, Commissioner Magwanishe. Commissioner Nyambi.
Yes, Acting President, just as we
Thank you, Acting President. It's a
follow-up.
It's a follow-up.
Oh, it's a follow-up as well.
Yes. Thank you, Acting President. Morning, JP Mlambo.
Good afternoon, Commissioner Nyambi.
It's very much unfortunate that in your interview we have to deal with this matter. But I think you know better than I do this process that when we have our closed session, you won't be there. And sometimes you'll have something that can be used against you. I want you to allay the fears in addressing the question raised by the Speaker. I know everywhere, even in Parliament, there are gossips. Everywhere, they will always have that challenge. But I thought it was going to be an anonymous source. But when you said it's a retired judge, then to assist us when having our sessions doing the deliberations, whether that retired judge was able to take you into confidence, where is this rumor emanating from? Because they are raising something very serious, sensitive in this country that has got that serious challenge, and you are being interviewed now. And as I said, you know better what happened when we get to the closed session. I don't want it to be used against you, so that we can have a proper clarification about this issue in terms of the source from this retired judge, whether he was able to assist you when you engage, when he called you about this sensitive issue.
I tried to probe the judge, the retired judge, Commissioner Nyambi. I said, but who is saying these things? Says, well, people are whispering about it here in Cape Town. And she wouldn't come out and tell me who those people are. I explored, I probed, I pleaded, and got nowhere. And it pained me to hear something like that, because I realized that something must have been at play here for people to start saying that. You know, so I probed. I tried all my best to get the retired judge to tell me who was saying these things, and she wouldn't budge.
Thank you, JP Mlambo. Thank you, Acting President.
Thank you, Commissioner Nyambi. Things are beginning to get out of hand now. Commissioner Mbofu wants to follow up on a follow-up question. Commissioner Mbofu?
No, it's fine, AJ. I don't want to follow up on a follow-up question. Actually, I wanted to follow up on the Speaker's point and the comments that came from the candidate.
Please proceed, Commissioner Mbofu, just brief.
Thank you. JP, yeah, sorry, I'm sorry, Acting President, that I just missed the turn to follow up at the correct time. You just said something that seems to be worrying me now, after I thought we had put this thing to bed. In your answer to the speaker, you are suggesting that this matter has come up for the first time in the context of the CJ interviews, and also that you think that it has been brought up, I don't know, I can't remember the words you used, to poison your interview. We have raised, I think I made it clear, people maybe I had some comments about how we were asking soft questions. That's simply because the chair, we've promised the chair that because of the seriousness of these interviews, whatever questions, easy or hard, but they must be asked in a measured manner, which is what I think everyone would have seen in the last 3 days. But that doesn't mean we mustn't ask the hard questions. I put to you that you know that there are rumors about kickbacks, about capture of your division, and so on. But you seem to is it your suggestion that if there is this other undercurrent or rumor about sexual harassment, that it should not be mentioned so that you are given an opportunity to deal with it?
No, we're dealing with it, Commissioner Mbofu.
Yeah, but you seem to be saying that it's brought in order to, as if there's some other motive for it being brought about, except giving you an opportunity to clear the air, which yes. I thought you had, by the way.
Yes. Yes.
Are you happy with that?
Yes, I welcome the opportunity. If it's raised, if it's worrying this commission, that it be raised with me. It's an important issue.
Thanks. Okay. And you agree with me that even the risk, because of the nature and the sensitivity of the issue, even the slightest risk of it ever surfacing in respect of our Chief Justice in a country is something that needs to be killed at this stage.
Yes.
Thank you.
Thank you, Commissioner Mbofu.
Acting President, Commissioner Barnard, follow up if possible.
Yes, Commissioner Barnard.
Thank you. JP, there's two statements that you made that seem to be rather concerning in your answer in the last couple of minutes. The one statement that you made was the nature of the legal profession is to backstab. And then a little bit later on, in a further part of the response, you said it's in the nature of the legal profession to gossip. Would you not say that those are two unfortunate generalizations?
Commissioner Barnard, I've been a lawyer and a judge. I've been a member of this profession for all those years, and I didn't say make those statements lightly. It is because that's the nature of that profession. It gossips. I can share examples with yourself about how when judges or people who are shortlisted, who must come to be interviewed, especially coming from the bar, where you found judges who still carry bar gripes or bar baggage, would try and influence me against supporting particular candidates, all based on rumors. So that's been my experience. So the answers I gave are based on my experience as being in the legal profession, that the legal profession gossips terribly, and it's in the nature of simply just perpetuating gossips that morph and take their own life and continue. So that's my experience, and that's why I answered it that way. And the backstabbing part is part of that answer. That simply because people were colleagues at a particular bar and they had a run-in regarding a particular issue, when one is now a judge and I receive a request from Commissioner Mpofu as chair of the Johannesburg Society to say, there's a list of prospective SIL candidates, can you get comments from your judges about what they say? Then all the baggage comes out, which is unfounded. So it's based on that experience, Commissioner Barnett. If I'm offending anyone, I apologize, but that's been my experience in the legal profession, that there's backstabbing, there's gossiping.
Well, it seems to me when you refer to legal profession, you're actually referring to the judiciary or members of the judiciary.
And lawyers and advocates. That's the legal profession.
And you don't think that that's, I'm thinking about the concept placing the judiciary in disrepute, because it's not something which is quite a serious allegation.
I suppose it can be viewed as serious, but the members of the legal profession who are in this room know that what I'm saying is what they've experienced as well. I mean, there's Commissioner Madonsela, he's nodding.
I grudgingly agree. Yeah?
That's because Madonsela gossips a lot.
For the record, I grudgingly agree.
Sorry, Acting President.
Thank you, JP. Thank you, Acting President.
Thank you, Commissioner Barnett. Commissioner Tsepe, at long last we have reached you now.
Yeah, there have been 10 follow-ups just before I could speak. Thank you, Acting President. Good afternoon, JP.
Good afternoon, Commissioner Tsepe.
Are you well?
Under the circumstances, yes, I'm well. You are one of those who spend my attempts to come and act.
I will not confirm or deny that statement, JP. JP, in the morning when you were speaking to your vision, the issue of transformation was you regarded that as critical, and the issue of acting judges is somehow linked to that, because you are creating a pool, and in creating that pool, that is then the pool that applies to come to the Judicial Services Commission for recommendation and subsequent appointment. So I think the issue of acting judges is an important matter. So what I wanted to raise is an issue that the Minister dealt with briefly, about some kind of a transparent and open process relating to acting appointments. It's not about what you have done, it's more, were you to be appointed a Chief Justice, the issue of acting appointments, either in the High Courts, an issue was raised by BLA with the SCA, and I think the GCB in their comments were raising about acting judges in the Constitutional Court. So in your view, as the Minister said, shouldn't we be having a transparent policy or practice on how that happens, so that allegations of the nature that it is not fair or transparent, and that we actually do get to reach all candidates, potential candidates who can come and act in our courts. For me, I think that would alleviate an important aspect that could alleviate all the criticism, because I think you are being the GCB in particular says you've done well in getting many people to act, but that criticism is, what is the criteria? Is it a transparent process?
I think it's a legitimate concern to raise that there should be transparency, and I subscribe to it. That's why I answered the question by what's happening in Gauteng. And obviously, as Chief Justice, if I'm appointed, I will have to push for more transparency in terms of that. And I think we will have to be guided as to what facets. I think I mentioned the key criteria of the experience at the bar or in practice as an attorney, So I subscribe to transparency, and I would support that it be transparent in all respects. I mean, just to buttress that, in Gauteng, when we appoint acting judges, if there are new acting judges that have not acted before, what is attached to the duty roster, when it's placed on case lines, are the profiles of the new acting judges so that colleagues have to know them, right? Who is this, what have they done, where do they come from, and whatever, because they're going to be colleagues for the term. So transparency is the way to go, I agree with you.
Thank you so much, JP. And linked to that is just the, and you are agreeing, but I'm just saying it's not just about appointing them, it's also the processes that you would have started implementing in Gauteng, where you to be a Chief Justice, we would want those systems to not just move out just because you would have left the division, but that it is something that then gets implemented elsewhere, including the support that would come, the support that you would provide to those acting judges. Yes. Would you agree?
No, I agree. I mean, it's a function of us as heads of courts, making sure that we do that.
Thank you, JP. Just on the very issue of transformation, and you're saying it's good, we have to have a national program. As I understand you, there is a committee of heads of courts.
Yes.
Why is that not already implemented you participate as the leader of the judiciary already in that? This, as you rightly say, a key component and should, in my mind, be something that should be implemented as in yesterday.
Yes. You're correct, Commissioner Tsepe. I'm head of court, and Commissioner Tlaletsi is here. Maybe I'm misrepresenting the facts, but I don't think so. I don't think we have a national policy in the judiciary on sexual harassment, or no, not on sexual harassment, on transformation. I don't think so, because if we do, I've never seen it. So I want to plead complicit in not doing anything at that level, right? At the heads of court level, to ensure that we have a national policy. But I want to believe that my own actions in the division I had have been, even though there's an unwritten transformation policy for the division, but it's something that I've been doing in terms of achieving transformation goals in the division. So I hope I've answered your question.
You have, JP. Thank you so much. All I'm asking is that some of these issues should not be waiting, including the sexual harassment policy. I don't know if you would have heard yesterday, we had a discussion with President Maya, and as I understand, you are correct, there is no anti-sexual harassment policy in the judiciary, and those kind of policies should have been there a while, and we should be ensuring that we implement them. Wherever this process leads, because you are already a leader in the judiciary. Just the last issue I wanted to raise with you, JP, it's on the exciting modernization and I was glad you managed to slip it in as part of your priorities as well. The question I've been asking candidates is that obviously as practitioners we have seen the value, particularly during the lockdown and the COVID pandemic, the value of case line and online virtual hearings. It is a reality to most of us. But from an access to justice perspective, it still remains a dream for most South African litigants or possible litigants. You spoke briefly about one of the centers, advisory centers, I think that you referred to. Is that something that is happening across the country, or is it just here in Gauteng? Because I would like us to, in doing that, have a strategy that covers the country. I mean, were you to be appointed a Chief Justice, that would be what it is. And do you have any ideas how we're going to do so?
Yes. The Community Advice Officers Association of South Africa is a national body. It's got advice offices spread throughout South Africa. Unfortunately, some of the funding they obtained during the COVID era, especially covering the availability of data for offices, was not national. It covered some advice offices. And I'm happy that, I mean, we made an approach to the LPC. The LPC chair, Commissioner Lepu, was very receptive to the idea of grassroots entities assisting in terms of closing this gap on access to justice. And that's one aspect. But I think someone asked me if the accounting that we do shouldn't go deeper down. But in the same thinking, Commissioner Tsepe, there needs to be a discussion involving Legal Aid South Africa that has a footprint throughout South Africa. But you may find that its offices probably don't cover certain areas. You know, there needs to be a discussion within that role player and other social justice actors who are in the space, just to identify the gaps as to how the whole country can be covered in ensuring that no one is left behind. So I agree with you. It's something that I've always said in my speeches wherever, that access to justice is a key human right, and it's something that should be upheld. You know, Commissioner Tsepe, when someone who's being sued and being threatened to be taken out of a house responds to the summons and comes to the High Court and presents himself to the judge and says, I don't have a lawyer, the judge stops the proceedings, sends the person to the legal help desk downstairs. And because there's a rotational list of attorneys on call to help, the next on the line is called, and that attorney, that client, the relief you see in their face is that I now have a lawyer. I've got someone who's going to assist me, stand up and put my case forward. So it just illustrates the importance that it can't only be people who are able and who have access to funds who access the justice system. It should be everyone. So I agree with you. Something needs to be found. A strategy through an engagement with the justice sector actors at grassroots needs to happen to make sure that we cover all the gaps and we have something sustainable. One issue that I've raised, which I can raise for you, is Legal Aid piloted an internship project years ago. We had to go outside government to find money to employ about 100, I think it was 50 if not 100 interns, because a lot of university graduates walk the streets without getting articles or getting pupillage. Now, if the big law consumers or law consuming centers in South Africa were to have an internship program that is that wide, it would give access to these law graduates to have access and be paired with seasoned practitioners in how the legal system works. But it will also help That's our experience at Legal Aid South Africa. It will help with legal services offering. So these are things that can be discussed and be implemented.
Thank you, JP. Thank you, Acting President. I appreciate the time.
Thank you, Commissioner Tsepe. I make it 10 to 2 now. Load shedding is due to kick in at 2 o'clock. So this will be the convenient time to take the lunch adjournment, 1 hour. We'll resume at 10 to 3. Thank you.